I'm calling to order the Tuesday, June 2nd, 2015 meeting of the Township of South Orange Village Board of Adjustment. May we have a roll call?
Yes, Mr. Don.
Here.
Mr. Descala.
Here.
Mr. Polipiano. Here. Mr. Reeves.
Here.
Mr. Semper.
Here.
Mr. Shapiro.
Here.
And Mr. Breen.
Here.
Pursuant to Section 5, Chapter 231, PL 1975, this is to state for the record that adequate notice of this meeting has been provided to the public by posting and maintaining the annual notice of regular meetings on the bulletin board in Village Hall, by publishing the annual notice of regular meetings for 2015 in the December 2014 edition of the South Orange Maplewood News Record, and by filing said notice in the office of the village clerk. So the first order of business this evening is the approval of minutes from the two previous meetings. We had a special meeting on Tuesday, April 28th. I put in a comment, a clarifying comment, and a couple spelling changes that are in red ink, and the track changes. I don't think anybody else added any other changes.
I thought they looked good.
Okay, no other comments? So I move that we accept the minutes with the correction that you see before you.
Second.
Mr. Don seconds.
Okay, Mr. Descala.
Yes.
Mr. Polipiano.
Yes.
Mr. Semper.
Yes.
Mr. Shapiro.
Abstain.
Mr. Breen.
Yes.
Mr. Don.
Yes.
And Mr. Reeves.
Yes. We then move to approval of the minutes for the Thursday, May 7th meeting. And similarly, I made a couple clarifying changes in the red ink that you see there about on the second page regarding the water. Did anybody else make any that wasn't changes that weren't sent to everybody?
No.
No other changes?
No.
So again, I'll make a motion that we accept the minutes with the change that's contained herein.
I'll second.
A second from Mr. Don.
Okay, Mr. Descala.
Yes.
Mr. Polipiano.
Mr. Polipiano?
Yes.
Mr. Semper.
Yes.
Mr. Shapiro.
Yes.
Mr. Breen.
Yes.
Mr. Don.
Yes.
And Mr. Reeves.
Yes. Okay, the first case this evening is Frank and Tara Evans, Block 2104, Lot 21, Case 1019. This is at 53 Fairview Avenue. The applicant is seeking a C variance to construct a garage in violation of the required distance between the accessory structure and the principal structure. Hi.
Hi.
Go ahead.
You got to be careful. You talk right into that or grab
Right
it out.
into it. How's that?
Perfect.
Okay. Hello. I'm Carol C. Hewitt, P-E-A-I-A. I have an architectural and engineering practice. Address is 800 Kimball Avenue, Westfield, New Jersey, and I'm representing the Evans.
Please raise your right hand. Do you swear or affirm the testimony that you will give to this board is the whole truth?
Yes.
Thank you.
Can you give us some of your qualifications? This is for architecture?
Yes, this is for architecture right now.
Okay, so why don't you I don't recall you testifying before.
I
this
have
board.
not, no,
Okay.
but I have testified in front of many boards in New Jersey, Milburn, Maplewood, Westfield, Scotch Plains, Berkeley Heights, New Providence, Ridgewood, Toms River, Brick.
How many times have you testified before
How many
boards?
in front of
Ballpark.
boards? At least 100.
You are licensed in architecture
Licensed
in
in
New Jersey?
architecture in the state of New Jersey and also in engineering in the state of New Jersey.
Are you going to be testifying as an architect tonight or as an engineer or both?
I guess I could do both.
Do we have any questions? How do I spell your last name again?
H-E-W-I-T.
Hewitt. Okay. Do we have any questions for Ms. Hewitt? Okay, the board recognizes you as an expert in architecture and engineering.
Great,
Go
thank
ahead.
you. Okay, I plan to be short and sweet. Really, our case is very simple. I am here to represent Tara and Frank Evans, 53 Fairview Avenue, which is the corner of Gardner Avenue. We are seeking a variance to erect a 1.5-car garage, which will be 16 feet by 20 foot, 16 feet wide, by 20 foot 8 inches deep. And the reason why we're here is we need a variance for the setback to the primary structure. 20 feet is required, and we're proposing 10 feet to the main principal structure. It actually will be 6 feet to a ramp and 10 feet to a new deck, but I think the ordinance reads 20 feet to the principal structure, so that's what we're here for. So basically, currently, there is no garage on this property. There evidently is evidence of garage in the previous time. I know you have some pictures, and I'll be willing to put this as evidence if you want to mark that and pass this around. But as you'll notice, you'll see there's concrete pavers, which were run, the runs for the driveway in the past. Currently, you'll see a play structure there that will be coming down. We believe that this property was subdivided at some point long before the Evans were there, and probably the garage was on the property behind them on Gardner Street. So what they want to do is put back a garage. There currently is a shed that they're going to be removing, and we'll take the storage that's in the shed and be able to park a car, put the bicycles, the lawn mowers, the rakes, the everything, kind of get everything consolidated to one structure, which I think will be favorable. In addition, you'll see different elevations. We've got the left side, the front, the right side, the rear is here. This stairway that you see here is a stairway coming out of the current kitchen. After we build the garage, we're going to be remodeling the kitchen, and we have plans for that already. It won't be adding any space, but we'll be removing these stairs here, adding a small deck, which is 8 feet by 12 feet. And currently, there's a ramp here, which isn't really working, so it's too steep. We're going to do a little bit better of a ramp, which will accommodate Tara's elderly mother and also the dogs. So one of the dogs is having a tough time, so that's the point of that. Anyway, so I will pass this around if anybody needs to see any more pictures. Thank you.
So are those the same pictures that were submitted?
There's a few extra pictures.
Would you like to mark those as A1?
Yes, that would be great.
And can you describe A1 for us, please?
So A1 are pictures that I have taken of the Evans house from different angles.
How many altogether, do you know?
Thank you.
12.
12. Thank you. So, anyway, you will notice there's also an existing very large tree. We had an arborist actually look at the tree, trim the tree, and that tree will remain, and he feels that it will be safe, and we should be able to keep that. So we will be removing the shed. I think there was a question as far as the lot coverage. So what I did was I actually looked at the total lot coverage, everything you see on the survey, which appears on pick this up. Okay, as you see, the survey appears on page A when we have the existing conditions, and then we have the proposed conditions. So what we're going to be doing is obviously adding the garage, adding the deck I talked about, the stairs, and the ramp. And there is currently a flagstone patio, and we're going to just kind of relocate that and add just move it over from its current location. In addition, we will keep the pavers in the driveway until we get to the fence, and then we're going to pave the last portion of the driveway so we can, they can put a basketball hoop or, be able to really park the car back there behind the fence. So that shows, I did the calculations for the lot coverage. Currently, we're at 29.6%. We'll be increasing it to 36.10% with everything. And that will be a net of 6.5% extra, or 650 square feet, and that will be under the requirement, which is 40%. So we really don't have any issues there. Just one other thing, is since this property is a corner property, and we obviously had to figure out where to put this garage, so I called Sal Renda, the town engineer, and we discussed it. I sent him a survey, we went back and forth, we looked at it, we said, what's the best place? And one of the things that he was concerned about is, we looked at possibly doing it from Gardner coming over this way, but we would have had to add another curb cut, and technically only one curb cut is allowed. There are currently two, but that's an existing condition, so we will be using the one we have, and obviously that's where the driveway and the garage previously were. The other thing, obviously, that might be of concern is that I wanted to maintain at least 10 feet from the garage to the structure, such that we meet the National Fire Code, such that neither structure will have to be fireproofed. We'll maintain that 10 feet, so that should be sufficient there. And just to note, we will be meeting the 3-foot side yard setback and the 3-foot rear yard setback. Basically, I just think it's probably a benefit to kind of clean up the yard, clean up the lawnmowers and the everything else that, doesn't have a place to live right now. I think it will make a lot of sense. We'll be able to put a car and all that stuff, and probably it will be an asset for the neighborhood.
Did your lot coverage calculation going up to 36.1 include the paving you're planning to do in front of the driveway?
Yes, it does.
And how far are you planning to pave in front of the driveway?
So that is going to be...
in front of the garage?
Yeah, just in front of the garage. Hold on, I think it's here.
What's the number on that drawing?
Yeah, here it is. It's right here on the drawing. So it's 10 by 34 feet in front of the in front of the garage.
A1.
And that is accounted for.
So it's 34 feet of paving, 10 feet wide.
Yes, that's correct.
But a portion of that's already paved by the concrete strips, right?
Right, exactly. That is true. So that is all those concrete strips right now.
I just wasn't clear what you said. It says, is the paving back by the garage? Is that the plan?
So we're going to pave 34 feet in front of the garage. There's currently a fence. If you look at those pictures, there's currently a fence
And back.
partway where,
I got it.
partway down that driveway. And from that fence back is where we're going to do the paving. That's 34
That's
feet.
the wooden fence?
That's that wooden fence you see. Mm-hmm. So it's behind the wooden fence that we're going to do the paving.
Do you know if the two-cut driveway has a previous variance approval?
I do not know. Was there one back there? It was existing.
Well, yeah, and I know it's existing. But, that's stuff that we come up with sometimes. That may be something that we would have to consider also is, Ms. Gruhl, what about this two-cut driveway here? Is that something we need to consider approving as a pre-existing non-conforming condition if we don't know if it had a variance before?
I'm not sure that really factors too much into what you're...
Use your mic.
Oh,
You're yelling at us.
I'm sorry. I'm getting, sorry. I'm not sure that would factor in significantly into the board's decision, because it is, I understand what you're suggesting is we don't know the status, whether it has legal status, but it's an existing condition, and I think that you can take that into account and its impact, because it has been used this way since the applicant has been in the house. Is that correct?
That's correct.
Whoops, I'm not sure that, are you sworn? I'm sorry, I didn't mean to get the
Did we swear you in
applicant up there.
previously?
First time.
Yeah, so you know
Okay.
you're still sworn in.
Yes.
Okay,
Okay, I'm sorry, Mr. Chairman, I just didn't want to
that's fine.
mess up protocol there.
Okay.
I don't know whether this would help. I do have a map on my wall from 1928, 1932 of the property, and it shows that driveway as existing in that map.
Okay. All right, so this is not something that's particularly relevant to this application.
I don't believe from a
Okay.
planning perspective it is.
Okay.
Mr. Chairman, I'm looking at section 92-128, driveway location and design criteria, and I don't see any reference to that aspect of the driveways, except that
Speaking of the mic.
they must, of course. The driveway layout may conform to these guidelines, but conditions may dictate deviation from them, and requirements of municipal engineers shall be final. Sal has seen these plans, so.
Okay. All right, so we'll let that one go. Okay, continue, please.
I
Further
think I'm done. I
questions?
think
Yeah.
it's pretty simple, so if there's any further questions, I'd be happy to answer them.
Just a couple other nitpicky questions. So the coverage includes the front porch, that front driveway, and the two strips of tire tread pavement area.
Right?
Okay.
Yep. Absolutely. Everything you see on that survey, it's included.
Why is your proposed plan so muddled? I mean, it seems to have existing and proposed over the top of each other.
Well, I think that was redone after the fact, and I know it was delivered. I don't know if you got the newest copy. There was a newer copy done so that it was clear that it was an existing and a proposed. Oh, wait, here it comes. I think here's a copy. Oh,
Yeah, I don't know why I didn't get that. Oh, wait, no, that's not it. Well,
That's a lot better.
I think that's what you're looking for.
yeah. Thank you.
okay,
Did
great.
that get delivered recently?
Email.
Oh, I don't think I got it. I don't think I saw
Yeah,
it.
to come via email, that's correct.
That's fine.
All right.
Thank you.
Okay.
Do you have any more questions, Mr. DeScala?
No.
Do we have other questions for Ms. Hewitt? Mr. Polipiano?
Can you walk me through the changes in the patios? So just from I'm just from a coverage point of view, are you removing the patio that's now going to be half under the garage?
Right, so sorry. If you look at the existing conditions, there's a patio and it goes goes behind the house and then kind of where the garage is. All that's coming out.
Oh, so that kind of ladder-shaped patio flagstone that's on the original plan is all coming out.
That
And then
is
there'll be a new
completely coming
patio
out.
built to the left of the house.
Right, we're just going to move it over.
Okay.
Right. It's going to be smaller than it was. But that will all come out.
We have other questions? No? Okay. Ms. Gruhl, do you have any questions for Ms. Hewitt?
No, just well, I guess just one, confirming the material type on the garage, will it match the principal residence?
Yes, that's the intention, to match the principal residence. So that actually shows we've got the siding to match. It's a cedar clapboard right now, and we're just going to match that. So that shows on section A, on page A1. And our intention was to kind of match the style of the house as best as possible, with still maintaining the 15-foot height, which is the requirement. So we'll comply with all those other requirements.
Thank you.
Okay, you're welcome.
Excuse me. Are those Is the roof made of wood shingles from that picture? Is the roof going to have wood shingles on it, or
No, they're asphalt shingles.
asphalt? Thank you.
Correct. We'll try to match that up also.
Any other questions? Do members of the public have any questions for Ms. Hewitt? Okay. Do you have any other information you wanted to present?
No, I think that's it. Thank you.
Okay.
Can I just ask one more question? Can you tell me on the lot, to the lot that the garage will be attaching to, it shows in this, I guess, survey, it shows as a one-story house that's pretty far forward in the lot. So there's nothing in the back in the back of the lot that the garage is going to be close to, but to, are there any of the structures back there, or is it just the house that's far forward? There's a house in the back.
Yeah. I think it shows.
You're talking about lot 20?
Well,
Yes, lot
either of the adjacent lots, I assume he's talking about.
Yeah, in the house, no, not in Kenneco.
Yeah. No, there won't be anything there. There is nothing there, so it's just what you see.
Okay, and on lot 22?
This is lot 22. There's the house there, and they have like a little shed there.
Okay, but the house again is forward.
It basically starts where the enclosed porch is, where the shed is. That would be right about where that house is.
Mm-hmm.
It's right about where you see the 100. That would be about where that house starts.
And again, there's no other structure in the back of that house that would abut this garage.
Yeah, just there's a little shed back there, that's all.
Thank you.
Okay.
Thank you very much.
All right, thank you. Okay, so do we have questions amongst ourselves, comments?
You asked for public comment, right?
I asked for public comment, yes, and nobody raised their hand. Nobody had any comment or question. Yeah, so let me be explicit. Thank you, Mr. Dwyer. If you had comments as opposed to questions, this would be the time to come up and give your comments for or against. Nobody? Okay. So, anybody want to start briefly, at least?
Well, I'll say that this type of application is not new to us. We've seen it before. It's a kind of variance that's got to do with the relationship of an outbuilding to the main structure, and the distance is what the variance is about. This lot, as in many of the applications that we've looked at before, it complies in every other way. And we've heard no negative comments from the one source that we've always thought that it was there for, which was the fire department, as well as in this case. So, I mean, I'm going to cut to the chase and suggest that we just approve this as it stands. Doesn't pose a problem with regard to bulk with the neighbors. Doesn't have a negative impact on the neighborhood. In fact, as the architect proposes, that it would clean up the yard and get a lot of the kind of things that you might store outside, either in a shed or a lean-to or under a tarp, into a garage, which is good for the neighborhood.
Yeah, I agree with everything you said. I'll add onto that for the resolution's sake that the other thought about what was the purpose of the separation was to decrease the sense of rambling masses of accessory structures. And in this case, the near distance of the garage to the principal structure, I think, is outweighed in a C2 variance contemplation, that it provides a more valuable residence by having a garage with storage room than any possible detriment from a few feet closer to the principal structure.
Well said.
Any other comments? As far as negative, I agree with you. I have nothing to add there.
Yeah, and I think looking at I think the issue about curb cuts, even if it's not a matter of law, I think the idea of having a third driveway opening on a suburban lot seems a little excessive and crazy. And so trying to use the existing curb cuts kind of limits what you can do here. You know, there is that.
Speak into your mic.
There is that nice space off to the side that you sort of wonder if there's a way to use, but it's a corner lot, and it would definitely require another curb cut. And so I think given that constraint and trying to work within the existing curb cuts, it's difficult to see where else you would put it.
That's a good point.
So I agree. I think and I think it's far enough away that it solves the massing problem. So I'm
Right.
fine with it.
That is a very good point. I mean, from a hardship perspective, there is actually one there.
Yeah.
You can't put a garage anywhere else without having to add a third curb.
Yeah, and I don't have a.
Or to the coverage of the property.
I'm sure, Bill, you wouldn't be able to measure this for me, but you know, even if you put a curb cut on the Gardner side and came in and tried to tuck the garage again in the back someplace, it's still probably going to be within. It's
Right.
still going to violate the 20-foot setback just
Correct.
because the position of the house and the lot.
That's right.
And so I don't think even if you did that, you would still need a variance, I think, right? So I think given all that, it's the best solution possible on this lot.
Well, that said, I'd like to move that we approve this case and this application as it's laid out on their plans.
Can we have a second?
I'll second.
Mr. Don,
Yes.
Mr. Reeves,
Yes.
Mrs. Semper,
Yes.
Mr. Shapiro,
Yes.
Mr. Breen,
Yes.
Mr. DeScalo,
Yes.
and Mr. Parlapiano.
Yes.
Okay. Enjoy your garage.
And a half.
Okay.
Thank you for sitting through last month's hearing as well.
Okay, so now we move on to St. Paul's Outreach. This is continuation from May 7th. This is 315 Self Place. And there's been some developments since our last meeting that we're going to address. We were at the portion where we were taking public comments. Since that time, there has been one of the neighbors, Mr. John Lopos, has hired an attorney who has sent us a letter, and the attorney representing Mr. Lopos, who previously spoke, would ask to present these concerns. And then in addition, Ms. Birkenwald gave a rebuttal letter to these concerns, which obviously we would need to address also. And then in addition to that, I have a couple more questions, clarifying questions for the applicant, if those can be answered tonight. And then we would continue on with any other comments from the neighbors. So I think that sets in line what we've got here before us. But I'd like Ms. Birkenwald to see if she had any comments right now about this, what we plan to do.
Well, again, at the last meeting, Mr. Lopez did give his opinion to the board at the end of our presentation of testimony. So he's coming in with an attorney rather late in the procedure. And I understand that the board is going to allow the attorney to present the witness who he's brought today. I did not make a summation. I would like to do that at the end of the procedure. So if at this time you want
Well,
to...
shouldn't the summation come before all the people make their comments? Or can we allow that?
No, it'll be done at the end.
Okay, all right, fine. I understood your objection, Ms. Birkenwald, to the attorney, but We are going to allow the attorney for the neighbor, for the objector, as well as the planner to speak, because this is an unusual application. It's a complex application. Its development has been one that's been difficult for this board to understand, and it's evolved over time. Even if I may say so, the applicant's presentation of this particular request has developed and shaped over time. So it doesn't surprise me that an objector would kind of realize, oh, okay, here's the deal, and then ask an attorney. I've also read the attorney's concerns, and whether we would abide by them or not, I think they are entirely relevant and reasonable concerns. So that's another reason we're going to let them talk out of that fairness too. And obviously you'll be able to ask questions too. Okay?
Mr. Chairman, Richard Skolnick from the firm Brown Moskowitz in Callan on behalf of Mr. Lopos, who resides at 311 Self Place. So I have three things I'd like to do, all relatively brief. The first is I'd like to address the legal type issues that I've raised in my June 1st letter. The second, I would like to put Mr. Lopos back on simply to authenticate some photos that he's taken of the site. And finally, I do have a professional planner to offer some additional testimony and thoughts for your consideration. I would estimate that would take about 10 to 15 minutes on the planner. So at whatever time you think is appropriate, I can get started, do those things, or you'll let me know when the right time is.
Well, I think we should get started with you first. I think that it might be better, actually, for other people in the audience. Your presentation of your concerns might also be a more cogent presentation, if I would anticipate, of some of the residents' concerns. So it may help everybody by having you go first. So that's what I'd like to do.
Mr. Skolnick, do you represent only Mr. Lopos?
Correct, Mr. Dwyer. And can I confirm that everybody has my June 1st letter?
Yes. Does everybody have it?
Copies if necessary.
I read it. I don't have a paper
Could I get a
copy.
copy, please?
I can get some copies.
If I may just state, it's one thing for Mr. Skolnick to bring another witness in, but Mr. Lopos did testify before the board. He questioned almost every witness. He was involved from the beginning, and he made a detailed statement at the last meeting at the end of the testimony. So to bring him back up for further testimony after the case was closed is not being fair to the applicant. This board follows certain procedures, and to have him get his second shot at the apple is going a little too far. I don't object to Mr. Skolnick bringing a planner, but I don't believe Mr. Lopos should get a second time to testify. He could have done that much earlier.
I hear your objection. We're going to allow him to testify.
I do have one question about, I know Mr. Skolnick is here as an attorney for one of the neighbors, but it seems like, assuming he's going to be speaking about his letter and explaining his positions, is he also a witness in the matter, and should he be sworn? I don't know what the protocol is for that.
Are you not going to will you be making factual statements, Mr. Skolnick, or legal arguments?
I'll be making legal arguments. I'm happy to be sworn if you like. It's somewhat not customary for the attorney to be sworn because I'm not a witness, but I'm happy to do so.
You drift off to the factual statements, and we'll swear you in.
Please let me know if my advocacy is such that I drift off into factual testimony. Mr. Chairman, just so we're clear, the only thing Mr. Lopos is going to do is to authenticate some photos that he's taken in support, essentially, of the comments that the planner is going to make.
Right, and that was and I should have said that in response to Ms. Birkenwald. We're not interested in hearing him repeat what he said before, so that's fine.
Are these photos that he has submitted before and represented before?
Excuse me?
Are these photos that he's already represented?
I don't believe so.
So we haven't seen them.
Okay.
Okay, go ahead.
Mr. Chairman, is it necessary for me to mark my June 1st letter? Is that considered part of the record?
It's considered part of the record, is that?
Thank you. So,
Wait a second, Mr. Dwyer has got a look of
I think it's a
concern.
good idea to mark this because we've marked objections exhibits up to now. I think we're up to 02. Is this the 03? I'm going to mark this 03.
okay. I gave out all my copies, but there should be an extra.
It's like 5 extras.
Okay, Mr. Chairman, I'll attempt to be brief. I've tried to do my best to lay out the legal arguments. First, we believe that there is a new variance or an exacerbation of a variance that's been recognized. We would suggest that there has been a miscalculation by the civil engineer, the planner, and the applicant concerning the required rear yard setback for a house of worship in the RA 60 zone. I've laid out in Exhibit B the requirement for the minimum rear yard in the RA 60 zone. It's either 16 feet, but then we have footnote 5, which states but not less than 20% of the average lot depth. That's Exhibit B to my letter. So on the rear yard, 16 feet, but not less than 20% of the average lot depth. As you know, this is a very deep lot, so 20% of the average lot depth is approximately 89 feet, because we have an average lot depth, as calculated by the project engineer, of 446 feet, I believe. Pursuant to the conditional use requirements, that required rear yard setback of 89 feet has to be doubled. So we're looking at a required rear yard setback of 179.4 feet and only 84 feet proposed. So we have a very significant rear yard setback that has not been recognized, no testimony on that issue whatsoever. We're going to provide information and testimony from our planner. The notice doesn't include that rear yard setback variance.
But that is an existing condition.
Well, the building is there,
Okay.
but it's not an existing condition for a house of worship, because we know from the extensive testimony that there's no prior non-conforming
You answered my
use.
question. It's an existing condition. The building is there. I know where you're going, but let's move on.
Let him, in a sentence, just finish your response. Let him finish it. It's
Well-
not an existing condition for conditional use.
Correct.
Right.
So we're in agreement. Okay, good.
Well, the proposed use is a house of worship.
Right.
That hasn't been recognized. There's no application for a prior nonconformity. So when an applicant, I will suggest, comes for a new use, they have to establish the statutory basis for that variance. That's our position. I think it's correct, because the use as a church is not established on this lot as we sit here today.
So that's the another objection that you had, that you've moved into, right?
Well, we're saying that the rear yard setback variance for a house of worship is required. It's approximately 95 feet, not the 5 feet that's recognized in the notice, as testified to by Ms. Gregory, as set forth by the civil engineer.
Okay.
The proofs for that are a different situation, but we believe they've not been met here, and we'll have testimony on that. Second, I would suggest that what the testimony shows is that there are two proposed principal uses on this site. Frankly, I think that's relatively obvious. There is the residential part, and there are all the other uses that were testified to that I'll put into a capsule of house of worship type uses. We heard testimony about retreats, formation meetings with 30 to 40 students, administrative staff who work in the building, the chapel, the missionary meetings, the Monday night meetings. I believe there's been testimony that some of the staff of St. Paul's carries cards that show the address of Self Place. So I'm going to suggest that we have two principal uses on this site, both the residence and the house of worship. Why is that relevant? If we go to the next page, your ordinance says for parking purposes, if you have dual uses, you have to count both uses. And I think that makes sense under the facts here. If you have two separate type uses, you have the students, the young men living there, that's one factor in the parking. Then we have all these other uses, the visitors, the missionaries, the folks who work there. And section 92-201B, as I've cited on page 3 of my letter, states the following. Any building containing more than one use shall meet the combined parking space requirements for all uses on the building. So I'm going to suggest to you that when we do the parking calculation here, we have to look at the chapel part. That's 8 spaces for the 24 seats. But that 8 has to be added to the use of the residential part. There's 2 uses. Your ordinance says if you have 2 uses, it actually doesn't say that they have to be principal uses. It just says if you have 2 uses, parking has to be for both. And I think that's one of the struggles of this application, that there's simply not enough parking for everything that's trying to be squeezed onto this site. So, parking, what do we have? I'll repeat. For that chapel, your ordinance says 1 space for every 3 seats, 24 seats, that's 8 spaces. But then we have to add on parking for the residential part. And that's not so clear because we have 2 standards. We have your ordinance, section 92-201A, and that says 2 spaces plus 1 space for each roomer, like a person who rooms there. So 2 spaces for the building and 1 for each roomer. And I'm going to pick a number, but I think that's really up for grabs, and say 13. Because Ms. Birkenwald said, look, we'll only have 12 students there plus the supervisor. So that's 13. She agreed to a cap on that. So I'll suggest the benefit of the doubt. So that's 13 people living there plus 2 for the building, according to your ordinance. That's a requirement of 15 spaces. Then you need the 8 for the chapel part. That gets you to 23 spaces altogether. If we look at the residential site improvement standards, I'm not certain that they apply, but if we look at those, we have another issue that was not recognized. Residential site improvement standards say for a 5-bedroom house, you need 3 spaces. Ms. Gregory testified extensively that that's it. It's a cap of 3 spaces, nothing else. But I have cited in my letter brief and shown you that there's a footnote on the 5-bedroom, and that says 1 more space for every bedroom. That was not discussed, nor has it been recognized. So if you use the residential site improvement standards here, we get 3 spaces for 5 bedrooms, and then 1 additional space for every additional bedroom. Now that was a big subject, as you well know, how many bedrooms there, but let's call that 10 spaces altogether. I don't know how many bedrooms are going to be out there, but say 7 more bedrooms plus the 5, I say 10 spaces altogether. Not so clear, we have to add the 8 So I create a range of between 18 and 22 under the residential site improvement standards. If you take, as your ordinance requires, the combined total, so for residential site improvement standards between 18 and 22, under your ordinance, 23. You have this very significant parking variance. No testimony whatsoever on a very significant parking variance. And again, I think that goes to the heart of what the struggle has been, that this site is really underparked for the intensity of the use. And all the discussion has been about 8 spaces, 8 spaces. That's the house of worship calculation, which Ms. Birkenwald has just said today. This is not a house of worship, but they've taken advantage of the house of worship calculation to get to 8 spaces. I would suggest that we have a significant parking variance, and up to this time, absolutely no testimony on that. 2 quick points, Mr. Chairman, at the end. I won't belabor them. I think the notice is defective here. I've set forth a variety of reasons. The legal standards are clear. The public must be put on fair notice of the application. There's actually no specific mention of a house of worship in the application. There's no identification of the significant rear yard setback variance, no identification of this parking setback variance, no mention of site plan approval. There's no mention in the notice that site plan approval is required, no mention of a possible de minimis exception on the residential site improvement standards. For the residents, there's no parking facilities in the front yard, that's not mentioned, and there's no notice to the public utilities. If you go to the secretary, you quickly get a notice of the public utilities, and there were no public utilities notice. So for all those reasons taken together, I think we have a defective public notice. And finally, the point I made previously, just to clarify, because there was a lot of discussion about this, there is no application for a prior nonconforming use that is before this board tonight. No Section 68 notice, no Section 68 application. The applicant had that possibility. I'm sure you've seen applications to establish the rights that go along with a prior nonconforming use. We don't have any of that here, so I would suggest in evaluating the application, the proposed church use, the proposed religious aspects really have to be looked at from the scratch, from the start, that there are no prior nonconforming rights because nothing has been established legally about when those uses came into effect, when the Salesians, I hope I'm pronouncing that correctly, when they started, how many people lived there, what sorts of activities, what happened when those permits were issued in 1991. None of that has been established lawfully. So I would suggest that in your evaluation, you have to look at this as an application from scratch, and any suggestions to the contrary should not be given credence. So I thank you for your time. My client does appreciate the date is late for me to come into the case, but, Mr. Chairman, I think you recognize it is an extraordinarily complicated case with a host of legal issues, and my client understood that it needed counsel to discuss these issues. So we thank the board for the extra time and to allow me to come in and put forth this information for your consideration.
Okay, thank you. Do we have any questions for the attorney?
I don't have any questions for myself. I think I understand what the arguments are.
I'd just like to get clarification on the there's no legal argument made related to the historic use on the site. And we had, and I guess this isn't a question for you, but it's a question for our attorneys. We had someone who spent a significant amount of time there some 25 years ago, who was a participant in what occurred there, and he gave his recollection and testimony. Isn't that something that's allowed as legal proof and under the state of New Jersey
I
land
think
use
it
law?
might have been relevant to how the building would handle and accommodate the proposed use, but I believe Mr. Skolnick's correct. It's not actually an application to certify a pre-existing non-conforming use. That's not the nature of this application.
That's a very good point. It was just that there was nothing provided. It was the thing that I was taking exception to.
Right. And had it been that application, I think the applicant themselves admitted that the prior non-conforming use was actually abandoned, so it would have expired in any event.
Fine. I certainly have no questions of anything else that was mentioned. I'd like to hear if our planner has anything to say about it. Do you have any questions?
No.
Okay, Mr. Skolnick, were you going to present some photos?
You are. I'll recall Mr. Lopez simply to authenticate some photos. We'll hand those out, and then we'll move on to our planner. Going to mark this, please, as 04.
Mr. Lopez, please raise your right hand. Do you swear affirm the testimony you're about to give to this board is the whole truth?
Mr. Breen, can I get one set from Ms. Birkenwald, please? I'm sorry. Okay, I'm sorry. Did we just swear him in?
We did.
Okay. Mr. Lopez, I've marked as Exhibit 04 some photos. Did you take these photos?
Yes, I took all these photos.
Okay, and when did you take them?
2-month period from, I believe it was March 30th until around May 30th, all taken from my home.
Okay, and you put some markings on those photos as well?
I did. I made some notes to the photos to describe what I saw.
Okay, thank you.
Do we know how many photos, Mr. Lopez?
About 7 pages. There may be 2 or 3 per page, but it's a pretty quick read.
Do we have extra copies available for members of the audience or the public, I should say?
I brought 14. So
I brought 14 altogether.
There's a couple, maybe a couple
So,
extra,
Lopez,
if
if
you
you
could
would,
lay them on the end of the
Steal that from Ms. Gruhl.
stage
I'd
there so people
appreciate it.
can, or maybe pass it out so people can look at
Thank
them.
Mr. Skolnick, I count 9 pages of photos. Does that sound correct?
That sounds correct for the record on 04.
This is marked 04?
Right, yes.
Okay, Mr. Chairman, I'll call a professional planner, Gordon Gemma, as a witness. If I could have him sworn in, please.
Please raise your right hand. Do you swear or affirm the testimony that you will give to this board is the whole truth?
I do, and for the record, Gordon Gemma, Gemma, 68 Seneca Place, Oceanport, New Jersey.
Thank you.
Okay, Mr. Gemma, would you provide your professional qualifications as a planner for the board, please?
Sure, I'm a licensed professional planner in the state of New Jersey, member of the American Institute of Certified Planners, and have been so since 1989. In that context, I've appeared in front of hundreds of boards before the state. I've been accepted by an expert in professional planning by the Superior Court of the State of New Jersey and has testified in front of the state courts. I've testified in front of assembly and state committees in Trenton. I'm also a licensed attorney, admitted before the bars of the states of New Jersey, Pennsylvania, and Florida. I also teach a professional planning class at Monmouth University, Kislak School of Planning, and for a period of time, about 8 years, I was a member on planning boards and zoning boards like yourself, so I know the pain and suffering you go through when you sit here.
Do we have questions for Mr. Gemma? Is it Jenna?
It's Gemma.
Okay, so we recognize you as an expert in planning. Thank you.
Mr. Gemma, can you go through the file and documents that you reviewed in
Sure.
preparing for tonight's hearing?
Sure, just to be quick and try to be brief, recognizing that we did come in late. I reviewed the application, the plans, and other correspondence in connection with this application. And this also includes a review of some of the notes that were taken from the prior hearings so I could try to familiarize myself with what was testified in front of this board. I examined the village's ordinances and master plans. I reviewed the letters from the applicant's counsel as well as from Mr. Skolnick, and I also had a chance to not only go to the property and look at the property from some of the neighbors, not going on to the applicant's property, but also tour the area to get a context of the neighborhood and an idea of some of the concerns that are being raised.
Okay, now I want to go right into the SECA balancing test, which will examine on the negative criteria for the D3 or conditional use variances.
Sure.
You're familiar with that standard?
Yes, I am.
Okay, and can you just go through the variances that you've evaluated, the parking in the front of the building and the rear yard that I discussed earlier tonight?
Sure, and just to cut to the chase. First of all, there was a query about whether this exists or doesn't exist. This is a variance. There are 3 variances from the conditional standards for a new application of a house of worship that has not been previously approved. I saw the prior plans. I saw the prior application for a modular unit to be added to the back of the building. It didn't ask for relief as a chapel. It was simply for an extension of residential structure. So this is new. And in the context of being new, you have to then say, how does this, even though it exists, how do you go through the steps and the criteria for the 3 variances that are needed? And those are, as you're aware, parking in the front of the building, it's not permitted. The side yard variance, which I acknowledge is minor, and the big one is the rear yard variance. And I agree with Rick's analysis that pursuant to your ordinance, the rear yard is not as indicated originally. There is a doubling requirement. And so when you get to the issue of 89 feet, you got to double it. I don't know how you get around that issue, but that's what your ordinance says pretty much in the footnote. So you got to say, all right, you apply it, it's doubled. And so that becomes a substantial variance. And to get to identifying the public interest, the 4 parts of the SECA test, Mr. Skolnick wrote, and I concur, that there are essentially 2 uses on this property. There's a residential use and there's a religious use. And that's part of the reading through the notes and part of when I was reading this, part of the real issue here. I have 2 different types of uses going on, and how do I balance between those 2 uses as applied to the variances that are needed from the conditional standards? And tonight, the church use is before you, and that's the core of the application. And Rick is correct. There was a residential part of it, and they testified as to the residential part that the students there, they live together, pray together, share meals together, share a common kitchen, shop together, engage in Bible classes. That is a residential component, and that is not what we're really here for tonight. We're for the religious component. That's somewhat different. However, we could get into an issue about what that residential component might be, but I'm not going to go into it tonight. I do have some concerns based on a testimony given by the applicant himself when they were discussing it. But if they're truly living together as a family, and if they meet the criteria of a family, and they have rights, and I don't believe that's the issue in front of the board. The real issue is the church religious use that you're seeking the variance relief from tonight. And that is, as Rick indicated, and as my review of the notes from the testimony, that there's a lot of other activities going on. There are retreats. There is events for students held a couple times a month. There is, even though the chapel is not open to the public, the chapel is used by the students and could possibly be used by the students, guests that are coming to the chapel. There are formation meetings. I'm not quite sure what a formation meeting is. There's the use of the building for administrative staff. They acknowledge there's going to be administration going on there. There are workshops for events for students not residing in the house. There's meetings for missionaries. That's all the, quote, religious use. And so when you go to the issues of the variance relief, you've got to separate those 2 uses, and you have those other uses. And I would suggest that the public interest at stake, which is one of the issues here, the expression of religious freedom, can be satisfied in very large part by the residential uses. The kids, the whole purpose of this was to get together and use it for students to pray and mentor one another. The other uses, the administrative uses, the outreach programs, that's something a bit different. So when you look at the public interest at stake, the religious use, I acknowledge that, but I acknowledge that can be done in a residential structure. The office use, the formation meetings, the use of the building for administrative purposes, they can all take place someplace else, and they sometimes do. During the testimony, when I read the notes, when they were asked, well, where's your office? Well, my office is at Seton Hall. All those other uses can take place at Seton Hall. And that's not in any way denying the ability, that religious freedom, but it can take place appropriately at another location. So on the first step of the Sika balancing test, I think the board can and should separate the residential component of the religious use from the remaining components, which can easily be consolidated and take care of someplace else. The second step is identifying the detriments to the community from the deviations related to the conditional use variance.
Can I interrupt you?
Yes, sir.
Because you just went over something that's very complex.
It is.
So what you're saying, if I understand you correctly, is that even though there seems to be an admission by both the applicant and by the objector that there are two uses, the applicants described it as a residential religious use, and you're claiming that it's two principal uses. You're saying now, if I understand you, that you would like to somehow, in the Sika balancing test, divide those uses and have only a portion of that portion of the religious use which is residential should exist here, and every other religious use should not?
No, I'm not saying that. I'm saying when you look at it, that there are clearly two uses, but that if you say that the religious use doesn't meet the other standards, the steps of the Sika test, the detrimental impacts, you're not denying the expression of religious freedom. The students can still get together and pray. The students can still come for the purposes, meet and live together pursuant to the tenets of Society Paul's Outreach, St. Paul's Outreach. So I'm saying that and it's tough. And that was, I think, when I read one of the comments from a member of the board, I think I forget which one it was, but it said it's really hard. Well, want me to focus upon 12 students living together? Want me to focus on there being a church here? And it's an integrated use. But when we're looking at the conditional use standards, and you as a board are faced with the tough thing. These are integrated yet separate uses. Because the residential use,
they are integrated. And doesn't our LUPA protect pretty much all those aspects of the religious use?
Well, I don't know if our LUPA protects, let's say, the administrative use. I don't know if our LUPA protects, let's say, the formation meetings where they try to and bring people in. Because it can take place, you're not denying the expression of religious freedom, it can take place elsewhere.
But isn't that true for every house of worship? You could say those uses can't be on this property, they can take place elsewhere?
Well, what you have to look at then is if those other houses of worship, do they meet the conditions for a house of worship? This case, we clearly don't. And are the negative impacts from their failure to meet those conditions of the house of worship? And my opinion, as we're going to get to it, is there are. But I think when it goes to the first step of the Sika balancing test, the public interest at stake, this board can look at it and say there's really two different aspects of what's going on here. There's a living together aspect, and I'm saying that if the board wants to classify what's been identified, how to live together as a family, then, which is the living to the residential aspect of it, there's still a religious component of it. And that there's a separate use, a separate aspect of it, the religious church aspect, and then you got to look at application of the variance standards to that, because then it becomes very difficult.
Okay, but the application is for that.
The application is for the variance standards.
You're right. The application is for that, and the board does have to examine what those detriments might be.
That's right.
Whether or not the site can accommodate it, but you're not suggesting that that this application should exclude those other religious uses.
No,
on
I'm
the site.
I'm suggesting that there are two different parts to it. There's two different aspects of what's going on here.
All right, but they're integrated. They are integrated.
I would argue that I don't know if you need an administrative office to have 12 people living together.
Apart from that, what other use would not be?
I don't know if you necessarily need to have missionaries and missionary outreach to have 12 people living together. I don't know if you need formation meetings to have 12 people living together. So, and this is how the applicant described the activities taking place there. There are other activities separate from the residential activities. Now, I'm just saying
you're going to find it hard to defend an argument before any court that says certain aspects of a religious use shouldn't occur on the site.
I'm not saying it shouldn't occur until we get to the negative aspects.
But what impact does
Well,
do those other uses have on the rear yard setback
Well,
or the side yard setback?
let's get to that. That's a good question. Let's get to that.
Mr. Dwyer, what we're saying is the first step that the board has to follow, not our LUPA, according to state law, the first step is it has to evaluate the public interest at stake. We know that's the first step. And we're saying that there's two separate uses. It's our suggestion to help the board to evaluate this complex application, that they, if the board desires, they can be separated. And the students living together, the residential part, has a set of public interests that are relevant.
What you're suggesting is that it should
Pat,
be...
you gotta let me finish, please.
You're suggesting
Can I
that the
finish,
residential use would somehow lessen the rear yard setback nonconformity or make it more acceptable to the neighbors, less detrimental. I don't understand
We're not on
how...
the second step, we're still on the first step of the balancing test.
But even if you try to parse the religious uses, you're going to run into trouble trying to defend that. And if you take them away from this applicant and all you leave are the residential uses, then that's not what the application is.
Well, look, we don't know what the application is, because we have a letter tonight from the attorney saying this is not an application for a church. What Mr. Gemma is arguing is that these other meeting-type uses, people working there, administrative staff, unrelated, we believe, to the students, the Monday night meetings, the formation meetings, the meetings of some missionaries, they can be looked at slightly differently in terms of the public interest at stake. That's our argument for the board to accept or reject. We're saying they can be looked at a little bit differently, and we're also suggesting clearly that the public interest is somewhat less for those. That's the first step, because some weight has to be given to the proposed uses on some unknown scale. And we're suggesting that the residence part can be viewed differently as all of these other uses, because they can easily go on someplace else, they are going on someplace else, and they have different land use impacts.
But they've been described as the mission of this particular group. They have been described as part of the mission. So I'm not sure how we can say that they shouldn't be allowed.
Well, anything, the group can describe anything as its mission. We appreciate that, but we're saying these office and group meetings, when you're smack in the middle of a residential zone, have to be looked at a little bit differently.
Okay.
That's what we're saying.
All right.
When you have a delicate balance of a conditional use that's right in the middle of a residential zone, what happens if they said, it's our mission to have rock concerts, and we think that's fabulous because it's part of our mission to have music concerts every Friday night where we try to have 50 or 60 people.
Would it be gospel music?
Say it would be. That's the issue. That's the exact issue here. Because if a church is permitted, that argument. Wait, Pat, please let me finish.
I know where you're going.
That's the exact argument. That once the church is there, the next argument will be gospel music.
I know where you're going.
Rightfully is part of our mission, and we should have it there. And we're saying the detriments. It's not sufficiently parked.
What you're suggesting is that the board ought to look at what uses this applicant in particular wants for this site, and then be very particular and very precise in whether or not they're allowing those particular uses.
Well, the difficulty is patrolling that after, because there's a body of case law that says once a church is established, they have rights to do a whole sort of different uses that are all related. And Ms. Birkenwall and Ms. Gregory have made that point. They've said once the church is there, there's all sorts of accessory uses that are part and parcel to the church. And that's my client's worry, and that's exactly why we're here tonight. Because once the church is established, the church will say gospel music. The church will say soup kitchen. Good uses, don't get me wrong. But on this site, that's the difficulty. Once the church is permitted, there will be creep. Near impossible to control it, I'll suggest. And that's the worry about the neighbors. That's exactly the worry that they have. It can't be controlled.
Is that impacted by the rear yard or side yard setback?
We believe that it is. That's our argument, because the building is mislocated on the site, and the parking.
Well, if the minimum lot size for this use is an acre, and this exceeds that, and you're saying you have to double the rear yard setback, wouldn't it be almost impossible for any building of any size to fit for religious purpose on a 1 acre lot?
We don't know what we don't know what that analysis is, and if it's not sufficient, then an application could be made. We don't know. That analysis is not in front of the board. That would all have to be laid out, but critically, there would have to be a parking analysis because your ordinance says if you have multiple uses, you got to park them. So I think you have regulations when you have assemblies and other things. So if it can be laid out
All right,
and there's
all right.
no
Why don't we let Mr. Gemma?
Okay, we're on step 2.
All right, let me just go back to
Sure.
one other point, and I think that goes to your point, Mr. Dwyer, and that is, if you don't separate the two, then if you take the argument you just made and say that the religious and residential are so intertwined that every aspect of the residential then you can look at in terms of the negative impacts of the conditional use. And the applicant was tried, at least when I read the notes, and saying, well, you can't look at the residential stuff. The residential is permitted. But if your point is that residential and religion is intertwined, then when it comes to the issues of the setbacks and the parking, then the aspect of having 12 unrelated people, because they are intertwined, as you proffer, then you walk into that issue of, well, then how does that part, and we're trying to stay away from that part, actually, how could that adversely impact those conditions that they don't meet? So I see where you're going, or I see your argument or the difficulty of the argument, but the applicant tried to say you got to look at just the religious part, but if you're going to take both together, then when it comes to the analysis of the second part of the negative impacts, you have to say what are the big negative impacts, the real concerns. I believe that the variance for the rear yard is as properly, if you look at your ordinance, you can't get around the doubling requirement. That's all right. What's the negative impact of having, now if I take your line of arguing, they're combined, I'm now double with the way I should be. I've got a religious institution that's also residential, using your argument that they're not separate, that's half the distance it should be from the nearest neighbor. But the real concern is, I think, when it comes to the parking issue, and when it comes to the parking in the front and the impact that has in terms of, again, taking your argument that religion and residence are all combined now, because I can't separate the two, then what is the impact of having that many people having the parking in the front, particularly when the cars and the light, the noise, the parking next to these neighbors who they're going to be into. And I understand the applicant made a proffer. And the proffer from the applicant was that I'm only going to have 11 cars there. And that's it. That's 11 residences. The applicant also said that they can have guests. Female guests must leave by 10. Male guests can come anytime, back and forth. Well, amazingly enough, they may have cars too. And if you say, well, the cars can't park on the parking lot, where are they going to park? On the street? That's more of an impact to the neighbors. And that's part of the concern of when you look at, all right, now parking becomes an issue in terms of the setbacks. And so if you take Mr. Dwyer's point, that I can now look at the residence and religion together, it's all part of the same mix, then I can look at all those impacts that go into the religion and the residential together of having this many people living in that one location and not meeting the parking standards. And what does that do to the neighbors that are living there in terms of having to deal with the cars going back and forth through all hours of the night? And then, again, these are good kids. Wish my kids followed things like this, but they're college kids living together in a group, and they're studying, and they're going back and forth. Okay? And the impacts that has upon a residential neighborhood, not only upon the residential neighbors in terms of the adverse impacts, is something else that you have. When I said I looked at your master plan, and you look at substantial detrimental impacts, it's not only on the neighborhood, but it's on the intent and purpose of your zone plan. And your zone plan is your master plan. And in 2011, one of the objectives of your master plan was to preserve and protect the unique character of historic districts. This is in the heart of a historic district. I drove around to get an idea of what this historic park was in this historic district, because I'm not familiar with it. And it really have wonderful residential, big structures, beautiful structures, but in a historic area. And you have to ask yourself, does this allowing parking in the front have an adverse impact upon the intent and purpose of what you defined as one of your more significant historic areas in the village? And in my opinion, it does. And particularly if you go the step further of saying, I can't separate religion from residential, it's all the same, well, then I got to look at the impact of these 12 cars, religion and residential, and the people that are coming on that intent and purpose, that objective of zoning that you have to try to preserve and protect the historic quality of what exists there today. And so the third step is, if you think there are impacts, how do I ameliorate the impacts? What do I do? The applicant proposed buffering, which is nice, but the problem becomes, and the applicant proposed, I'll only have 12 people living there and only 11 cars. But again, how do you control guests that are coming there? You can't really, unless you say no parking for guests, and then who's going to enforce that? Because the only person that's going to enforce it is the guy in the house who has a guest coming. You're not going to know the difference. And if you enforce it, then where are they going to park when they come? And you have a lot of people coming now in this residential neighborhood, parking on the street in front of your house where you don't have a lot of parking. So that's one of the issues, that the issue of parking begins to impact you. You also have the other impacts. Well, in the back, I'll buffer more of it. I'll try to put up more trees to take care of the noise that's coming from there. But in the heart of it, you have this use taking place surrounded by single-family residences. It's hard to say I can do enough buffering. I can pose enough conditions. You can't have an outside meeting. You can't have outside prayer worship. You can't have the administrator come there. Well, who's going to enforce those conditions? You're not going to have your zoning officer come to try to enforce those types of conditions, to have the creep that Rick talked about. As it goes from one thing to the next, you're putting more and more burdens upon your zoning official to say you now have to be the guardian of purity for the neighborhood to make sure that these things don't happen. It's not going to take place. It's not realistic. So when you look at that, is there enough conditions you can impose? At proffer, it's hard. And you've got to really think, how can I enforce those conditions other than to say this type of use, this quote, more religious use than the residential use, maybe it shouldn't take place there, but it's hard to enforce it. And so when you ask me with the last step, the balancing of the, can you grant the relief without the substantial detriment by imposing conditions, I think it's hard. I think it's almost impossible to do, and you're making it really difficult for your zoning officer to do that. And I think the problem you have is you have to look at the quality of your neighborhood, the objectives you have. And if you take Mr. Dwyer's opinion and say it's all combined, religious and residential, so interwoven that you can't separate the two, then you can look at all the other aspects of having 12 unrelated, essentially college kids living together, a good religious life. But what does that do in terms of the impacts because of the side yard, the rear yard, and the parking variance? The last comment I have is one of the bulk standard. And the bulk standard that Rick brought up is your parking. And what is your real parking? What do you need? And do you need a variance from parking or not? I think you do. I think if it's so intertwined, well, let's put it this way. You can't say that there's not a residential use there, that it's only religious use, no matter how you cut it. So you have religious use, and there's other use. Well, the other use is residential use. So what standards do you apply? I have to apply pursuant to this application itself. It has to be the religious standard. I have to apply that for a church because that's what I'm seeking the relief for. I can't get around that. So do you ignore totally the residential standard? Or do you ignore totally the very basis of the relief you're seeking? You can't. That'd be inconsistent. So you have to say, look, there, I've got a religious use, I've got a residential use. And the religious use is because even though it's open to the public, again, if I am maybe not going to be a seminarian, but I'm going on that path, and I have people coming over, they're probably going to pray with me. That's what I'm there for. That's the belief that I have. And they're probably going to go to the chapel and pray with me. So when you look at the two standards, if you're going to have 11 people living there and you have guests, real hard-pressed for me to say that 11 spaces cuts it. I don't think it does. I don't think your ordinance believes that. I think you got to combine the two, and whether you go by the RESA standards or by your ordinance standards, you don't meet them. And if you don't meet them, you need testimony to say, here's why I don't need it. Everyone's going to walk. No one can have a car. Well, no guest can park. Well, if no guest can park, where are they going to park? It's ludicrous to say that they'll never have a guest come. Where do the missionaries come from? They're going to all take cabs? I mean, so you have to say, how do I address those things? And that wasn't addressed. And those, someone who sat on these types of boards for years, those are the concerns that I would have. What do you prove? And I think until you get the testimony, it's hard-pressed for me to say, grant the relief, because you haven't addressed those questions. And those are the heart of the questions to the neighbors. That's why they're here. That's why they're paying stupid money for Rick and I to be here, to try to articulate those concerns and see how they can be addressed.
That concludes our testimony, Mr. Chairman.
I have a question for Mr. Jimla. Do you have any experience, even if it's just anecdote or better yet, anything in the published planning literature that talks about how you can reliably limit even self-stipulated religious activity? So, for example, the highest intensity use was, they mentioned that these formation meetings were on Monday nights, twice a month, and it would have up to 40 people. Is there a way to limit it to twice a month? I mean, is it a reasonable way? Is it done any place?
I used to represent, sad to say, as a good Catholic boy from Jersey City, I didn't represent a lot of Catholic institutions, but I represented a lot of synagogues, shuls, and other houses of worship. And there was always one of the issues, particularly on the high holy days, how do you regulate it? High holy days in religious faith comes just once a year. But once a year, there's a lot of people there. And as a rabbi once told me, every observant Jewish person walks to synagogue on high holy day, some from their house, most from their car. So how do I control all of that? And what you've done essentially is you then have the neighbors as the watchdogs and say, you're the ones that got to call when it's violated, you're the ones that you've got to call the zoning official. And the first time it becomes hard to administer, particularly when the zoning official doesn't work at nights. You have neighbors taking pictures of other neighbors. It gets kind of silly. Those are the types of things where it's hard to regulate that. And the only way you can regulate it. Now, that wasn't the formation meeting. How do my buddies over watching Monday Night Football? There's no regulation on the number of guests they can have.
Well, that's true at
any house, that's right. But here you have this combined usage. The concerns of the neighbors are, how do I keep it from creeping forward? And so I know that they tried, a lot of the cases that I had, they tried to impose restrictions, particularly during those days, and say, look, you have to really cut it down because those are the concerns about traffic and noise and lights and trash. And it's not that they mean to do it, just it's people. And the intensification of use, I found that every case I worked on was always very difficult unless you went to the absurd, when we had the high holy days, you have to have a police officer there. You're going to have a police officer there every time they have a meeting, so the police officer is going to regulate where you're going, what you're doing. I don't think you can do that. I think it's hard to do. But I understand that with the wrestling you're trying to have, how can I impose those conditions? And I think what you have to say is when you have 40 people coming to someone's house in someone's backyard, don't do it. Go to Seton Hall. You're not stopping the expression of religious freedom by saying there's another venue with a whole lot of room a block and a half away.
So I have a logic problem, right? And that's it. If you don't grant a variance with conditions, then you don't even have those conditions to enforce.
Well, I think the better way of saying it is you can't have the formation meetings twice a week, twice a month. You can't have 40 people come. You just don't do it. And if you have those people come, then...
How do you say that?
You basically
Are you proposing that we say that?
Well, the point is this. You can go one of two ways. You can say you can have it twice a month.
In what way do you say that? Do you say it with a variance?
Well, no, what you can say is you can impose conditions on any relief that you give.
Of course. That's what you're just saying,
right.
That none of that is enforceable, though.
But I'm saying it's difficult to enforce, if not impossible. Do I say have no conditions? Of course not. I'm saying if you give the approval, and you have another way, don't give the approval. That's the other way of doing it, that we've resolved that issue. And you could say those religious aspects, those things, those big events, don't take place here.
But it's the same issue, isn't it?
It's a little bit different, because I think that goes to the heart of that's why I tried to separate the religious from the residential. And Mr. Dwyer said he can't do that. He said you have to keep them all together because they're so intertwined.
We reject what Mr. Dwyer had to say, just in case that wasn't clear. We are not agreeing with him.
That horse
Just
is
want to
dead.
have that on
That
the
horse is
record.
dead, and I got it.
Right,
Yeah.
but I'm saying, but then it becomes, it's hard to do that. But if you were so disposed to grant the approval, then I would say, of course, you have to impose the conditions. That's one of the steps in the Sika balancing test of how to ameliorate the impacts.
Which
That's
we
the
understand,
heart-
right.
That's the heart of the, and so how do I say, if you're going to have a big meeting, first of all, I would say you can't have meetings of 40 people in someone's backyard twice a month. Don't do that. That's not a good thing. And if you want to have it at Seton Hall.
Sometimes the answer has to be no. When you have a very unique situation, like the configuration of this property, and the answer is no, because there's not enough parking, there's not the rear yard setback, there's not supposed to be parking in the front yard. Sometimes the answer needs to be no, there's another appropriate place. Your job is to balance. That's the Sika balancing test, assuming we are a church, of course. So we're going to suggest that in this circumstance, the answer, unfortunately, has to be no to these other religious parts. If this is truly a family living as a unit, they can live there and abide by all residential requirements, if it truly is. I don't think that's been established, but if it's truly a family, one family, and the board says no, the students can live there. They have parking requirements like any other place, but that's not the application in front of you tonight, I would suggest.
What if the,
This application says church all over it. I just want to point this out before Ms. Birkenwald disclaims that this was a church. This application, district use regulations permit church use. We're here for conditional use variances for a house of worship. That's what this application is. So I would suggest there can be a denial, and the residential part, if it's lawful, will go on. And there may or may not be enforcement actions if it truly is. But that is not in front of you tonight, I would submit.
So assuming that we were to deny, and we talked a little bit about this during the various hearings, I mean, don't we have vastly less control? Aren't, assuming that they simply say, okay, now we're a residence.
No.
And,
I'm sorry, Mr. Breen.
and and so they have parties every Monday, every other Monday with 40 people.
No.
It's not unheard of.
No, that you will not. In my view, 99 out of 100 cases, a court will, if it overturns, send it back to the board for the imposition of reasonable site plan conditions. In my view, that is the high likelihood. You deny, there's a lawsuit. We don't know how that's going to come out. It could be overturned, of course. Perhaps there'll be a lawsuit either way. Who knows? But the normal circumstance in my 25 years of practice is if a variance is overturned, the matter gets sent back to the board for the imposition of reasonable conditions. You will have control. My opinion.
You were just answering a question if there was a lawsuit, and that wasn't the question.
No, Mr. Breen said, don't we lose control and the ability to impose conditions if we deny?
And your answer is, in that case, no, if there's a lawsuit. But what if there isn't a lawsuit?
Well, if denied and no lawsuit, you have not lost control because they're not going to have the use there.
Well, I think that's the question. Not to speak for Mr. Breen, but that is the question.
That's the question.
Wait, if you deny the application...
We deny the application, and they continue to have a residence with multiple dwellers, and they do what they want.
They have to live within the regulations as a single-family unit.
Right. Which, I don't know about you, but I've had a few parties at my house, and I've had plenty of people park all over the street at my house.
Right, but
and if I had 16, 18-year-olds at my house, I'd probably have 16 times as many parties at my house.
Well, here's what they would not...
If it was just a residence.
Right. Mr. Descali, here's what would occur, in my view. You couldn't have the formation meetings on a regular basis.
Right.
Because that's not a residential type.
That's a
use.
church use, yeah.
Right. You couldn't have the administrative people working there, right?
Yeah.
We couldn't have missionaries stay there on a regular basis. Of course, you could have a visitor, but you have all of these other uses that were testified to. The regular Monday night meetings. We have people with business cards, I believe is the testimony, that have Self-Place as their business address. So if it's denied, life will go on. Presumably, the students will stay. There'll be a claim that they're a single-family unit, and they'll have to live as a single family. By the way, no parking in the front yard for that. No parking in the front yard. That's what the residents will have. Like every other, if the claim is that they're a single family, you're looking at me like I'm not saying. I could give you the citation if you'd like.
No, it's got nothing to do with citations. It's got to do with what experience has there been up until this point in time with regard to cars in front of the house.
I appreciate it, but if there's an enforcement action, that'll be up to the zoning officer. So
Right.
if you ask what will happen, if there's a denial, there'll be presumably a claim that the students have a single-family use. If that's accurate and that can be proven, then they'll be able to continue to use it. Again, subject to how every other single family has to live. I'd suggest my client, I don't know about the other neighbors, would be reasonably satisfied with that. They understand something will happen there. They understand there will be a use there. But what they don't like and what they're very worried about is the zoning creep for a house of worship where you cannot control, and Ms. Birkenwald and Ms. Gregory cited case law, you can't control the house of worship once it's in there.
Okay.
They cited law. It said, once we do this, we can have a soup kitchen. We can have gospel music there regularly.
Right.
All those other uses, that's the fault point that is highly problematic, and we're suggesting the board could say no, that there's sufficient facts and evidence in this record for the board to distinguish these two aspects of the use and say, look, the students living together has a certain group of public interests at stake and a certain type of benefit and there's certain things that are important. But this other, the business of the church, the people coming, that other activity, that's a little bit of a lower public interest. All inherently beneficials have varying degrees of public interest. And we think there is enough evidence in the record for the board to distinguish those two and say, look, these other sorts of uses, they could readily go to Seton Hall. They're not as important. The business offices, the music, they're on a lower scale. So that's the first step in the balancing test. And of course, we know the second step, the detriments, the conditions, and the balancing. So we think there is substantial control.
A couple questions for either of y'all. Is can a fraternity, a traditional college fraternity, be considered a single-family house in New Jersey?
Gemma has a response.
Can a fraternity, actually, I'm not going to bother to go in New Jersey. I'll go for your ordinances.
Our ordinances says that a family is not, a fraternity is not a family.
Well, in fact, what it says here, it was interesting. First of all, fraternities are permitted in the RU zone.
Right.
So, and so they're permitted in a different zone. Second of all, there was a colloquy back and forth, at least I read in the notes, about, well, if you don't permit this conditional use, there are other ones that can come around here that are permitted. First of all, fraternal organizations are permitted as conditional uses in this zone. But fraternal organizations also have the requirement they don't permit any overnight sleeping. So fraternities are permitted someplace else. Fraternal organizations in residential zones don't allow overnight sleeping. This wouldn't qualify as that. And so you have to be careful. You have a fraternity, there's a zone that's permitted, and it says fraternities and sororities are permitted in that zone, but not here. So that's not an issue that you'd have here, because you've defined it and permitted it someplace else.
If that was the question.
Would this the young men that are staying here, propose to stay here, be considered a single family as a...
You have an opinion on that?
Actually, I do. And I know there's the Glassboro decision. And it's a Glassboro decision, came out of the New Jersey Supreme Court in 1990. And it's Glassboro v. Valorosi. And Glassboro said that in this case, they considered the students living together a traditional family unit or its functional equivalent. And the court held that unrelated students constitute a family as they often eat meals together, cooked for each other, shared household chores, grocery shopping, yard work, and in addition, a common checking account paid for food and other bills, and they share the use of the telephones. Therefore, the court in Valorosi said it's a single family. Now, your ordinance has a definition of family. Your ordinance, which was, now Valorosi has been around since 1990. Your ordinance says that a single-family group consists of groups of persons, whether related or unrelated, not larger in number than any dwelling occupied or to be occupied by such groups may accommodate under the applicable housing code provisions, which constitutes a single bona fide housekeeping unit. Doesn't include social clubs, fraternities, sororities. And it goes on to say a single bona fide housekeeping unit for the purpose of this chapter is a relationship between persons for maintaining a common household or family relationship on a permanent basis or for an indefinite period of time. And that's interesting, because here, clearly the testimony established two things, I think, that make it somewhat different. Here, it's not permanent, not for a definite period of time. In fact, the testimony was it's only 2 years. Second, unlike Valorosi, or the Glassboro case, where they had a common checking account and they shared chores together, here the testimony was that they're going to pay similar to a tuition, a couple $1,000s a year. And for that tuition, I can live there and I'll get my meals, paid for by the people I pay the tuition to. You're not paying into a common checking account. You're not paying for a common household. You're paying a tuition to a third-party organization, a corporation, that in fact runs that place. Now, it may be a not-for-profit or a for-profit, but it doesn't make a difference. So do I think you meet the definition of Valorosi? No, I don't. Because you don't have that commonality that Valorosi in the Glassboro case talked about 25 years ago. When it comes to your ordinance, it talked about permanency. And in permanency, here you clearly don't have that. So if you ask me straight up, do I think you meet the definition of family pursuant to the Glassboro case or to your own ordinances based upon the testimony of the applicant? I don't think you do. That's not what we're here tonight to discuss. But thank you for asking the question.
Let me ask you another question. And I think this may have been getting to what Mr. Dwyer was concerned about is if you look at St. Paul's Outreach and you go on their website and you actually listen to the testimony, this is a proselytizing evangelical Catholic organization. Their mission is to convert people to Catholicism and a more traditional interpretation of following the Bible. And the main point I'm getting at is it's proselytizing. Its mission is to bring more people into the Catholic faith. So they're going to argue that this residential is inextricable from their outreach to people, that it's all part and parcel of the same thing.
Well, if they argue that it's so interwoven, then it goes to the heart of the question that Mr. Dwyer said. Then when you look at the negative impacts, not only do I look at it from a chapel, I look at it from every aspect of people living in that house. And that goes to the heart of what we're looking at here in terms of, is there parking in the front? Is there sufficient parking? What about the rear yard setbacks? Not just for the chapel use, but for every aspect of the use. So I think if you take it down that road, and which is what the applicant didn't want to do, the applicant wanted to say, look, we're just looking at a chapel, not everything else. Then I think the applicant's got a bigger road to hoe because, in fact, they have to say, how do I have to look at now 12 people, bringing people in as part of my mission? How do I ameliorate the impacts because I don't have the parking in the right place? I have the wrong rear yard setback. And what is the impact on the neighbors? and the impact on your zone plan that says preserve historic residential district.
Let me ask you about the parking. What about putting parking spaces in back? Our own planner has suggested that within the current, within the 7-foot setbacks around the perimeter, you could put 16 cars in back.
That didn't take into account the 25% limitation, I believe. She said specifically she didn't look at all of the standards. She didn't look, I believe that's what she testified to. She just looked at the 7 feet, but if you're going to be a house of worship, you have the limitation on coverage as well. So I don't think there's any plan that's in this record that's designed to show exactly how many spaces.
No, there is not from the applicant. This is an estimate from our planner.
Well, that's very unfair because I can't cross-examine
Yeah.
an estimate. I can't argue a napkin that went in.
Well, let me ask from a planning perspective.
And if, go ahead, I'm sorry.
Putting cars in back, wouldn't that be keeping in more in line with what we do as a single-family residence? You force cars into the back of the property?
And if this were a normal single-family residence on a normal lot, not surrounded by residential, I'd say you're right. But what this tells me is, because it's not a normal single-family residence, it's surrounded by other people's yards, that you're trying to, respectfully, put in too much intensive use, so many pounds of something in so small of a bag. That's why it doesn't work. And that's the concerns you have. You're really trying to intensify this use very greatly, more than it should be, given the context and character of the neighborhood.
Let me
Mr.
ask you
Chairman, in this regard, I did make a request, and I would ask the board to make a finding of fact about the applicable parking standard and the number of spaces that are required, giving roomers and bedroom counts. I reiterate that because that is critical, and I fear we'll be back here with a request from some other authority ultimately. But there needs to be a finding here of how many parking spaces are required and what the applicable standard is. In my estimation, it's somewhere between 18 and 23. Personally, I think the town standard applies. I don't think the residential site improvement standards apply here. And I think it's at least 23, and that could go up from there, because ultimately you're not going to be able to control the number of quote-unquote roomers, the number of guys living there. If it's successful, as I'm sure SPO hopes it will be, you'll have more kids living there. So even with additional spaces in the back, the site is still woefully underparked, and you could see what it looks like now with the so-called parking in the front yard based upon Mr. Lobos's pictures. That's a woefully inadequate, and I would submit very unfair parking configuration for your residential neighbors to be faced with parking like that. That's a significant detriment to see car after car lined up like that. And now we're talking about...
Okay, I got it. Yeah, you made your point. Quite
little
clear.
testimony. I couldn't help myself.
Mr. Jim, let me ask you maybe my final question. I'm not sure any religious institution in this town could be built without variances, and many of them are built with variances.
Yes.
And it's not, and we live with OHEB literally in our backyard, behind our backyard.
Mm-hmm.
It's not the end of the world. It's not the greatest thing. It's a lot better than a noisy neighbor, which I think is some of the residents' fear here, is what they might get in addition to religious use. But how are you ever going to bring in aside from RLUIPA, which is maybe my final question, how are you going to get a religious use ever? Because what the residents are saying, I would probably be out there sharing their same concerns, that I'd rather not have it here, let it go someplace else, because it could get, if it's not done well, it could get worse.
And as you know...
I'm not talking to you, sir. I'm talking to the expert. You'll have your chance to speak. We can't have people yelling stuff or we'll never get through. Thank you.
Thank you, Mr. Chairman. I was about to say, Your Honor. But as you know, and as the board knows, every application is treated on its own merits, and you've got to look at them. And in some cases, when the variances are minor, or they don't have the impacts, or they can be ameliorated, I'd say grant the variance relief. Because there is, and I want to be clear, there is a public interest that we're trying to, in terms of religious use. And I would never want to quash or adversely impact that public interest. But when you take the balancing, in this instance, I believe here, the particulars of this case say that here, since it's so difficult, since this is a unique piece of property, I've got to tell you, I've been doing this for about 30 years, and I've never really seen a lot like this surrounded the way it was for the use that's proposed. So you got me on this one. And I think here you've got to look at it fairly on the facts, not to say I'm going to deny anything. Because you're right, probably in a town that's built, almost everything requires a variance. But how do I take care of it in this instance on this case?
RLUIPA. Doesn't RLUIPA give almost privileged status to landowners advancing religious uses and that if you lose a case, attorney's fees are usual, and even rumored monetary, but I doubt it would be that kind of case. But we've turned down a religious application before, and we were threatened with RLUIPA. It's a real concern.
Okay, so, Mr. Chairman, RLUIPA is a statute. It's out there. That's not really a question for a planner. I don't think the board should shirk its responsibilities to fairly evaluate this application because of a threat of litigation and a threat of attorney's fees. There's always a balancing. There's a substantial public interest at stake here. And more importantly, what we're saying is, look, if the kids are truly a single family, they can live there and they can do almost everything that they need to do. But they don't have to have outside groups coming in. They don't have to have all these meetings there. There's other places that they can go to. So there's a balance to be struck here. We're here for a reason. The Congress did not say in 2000 you have to approve a church or a house of worship. That's not what it said. It said you had to make a reasonable accommodation. But here there's substantial interest at stake, like 20 people having to look at this massive parking and this massive jumble. So we have a recent case, 636 Inman versus Woodbridge. The court recognized that you can deny applications for inherently beneficial uses. So
I don't think that's an issue for this board, Mr. Skolnick. It's done it in the past.
Excuse me?
This board has done that in the past. It has denied house of worship applications.
Well, the chairman raised the issue of
it's not something the board has not done in the past.
I appreciate that, but
I think that there's an issue perhaps of respect here. I mean, the chairman is, as is every member of the board here, interested in the public good for the benefit of these neighbors. And the heckling from the neighbors at us while we're sitting here as volunteers trying to do what's best for your neighborhood is disrespectful. And to have you suggest that our chairman might be willing to shirk his responsibilities to avoid a court case is irresponsible.
I apologize, because that's not what I intended.
I didn't take that. That's fine.
This is the most sophisticated type of legal argument that there is in land use and zoning law. I'm going to tell you, right, I've been doing this 25 years. I'm the former chairman of the land use section. This case is one of the most sophisticated cases I have ever seen. There's no disrespect for anybody, but it's a very difficult land use situation.
And we are aware of that.
With multiple layers. So,
and we have denied churches. We have had lawsuits against us in the past from churches. We're very familiar with the whole process, and what we want is what's best for the neighborhood. So let's leave that alone.
I think just to go to the chairman's point about the statute, my understanding of the statute, and I'm not testifying to that as an attorney. I'm actually the only one of you who are supposed to testify as a planner. But the point of the statute was to prohibit the denial of the expression of religious freedom. And that's really the heart, I think, of the statute. And I think in this instance, because there are viable venues that the applicant itself testified within a block away that can accommodate all those same uses, I don't think you're denying the expression of religious freedom.
Do we have any other questions for the planner?
Can I just ask a legal question about that exact point? So is there case law to support that we can use that test that's been offered to say that the religious functions the religious need that is trying to be met on this property can be met close by, and that is a good grounds for saying, because there's impact on this site, that we're going to push it elsewhere? Is there any legal precedent for that?
We believe there is, that the viability of other suitable means or methods is a factor. Not saying it's the only factor, but I believe there's substantial support that can be.
I'm not aware of any specific case. Are you, Mr. Skolnick?
Not as we stand here tonight, but there is a significant body of variance jurisprudence, especially in the wireless field and other fields.
This isn't wireless.
Right, but these are variances. These are variance cases. So
no, I don't think we can
the
compare
answer
it
is
to wireless.
no.
No case law. Is there any? Well, let me just ask a follow-up question. Is there any case law?
I'd like a chance to brief that or put that forward if there is an opportunity.
Is there any case law to support the other idea you put forward, which is the gradation of value among the various uses, that rather than think about the religious uses as a whole, that we can think about them in terms of the weighting of those, right? Is there any legal support you would point us to support us doing that?
Well, I think the first step of the balancing test is to identify.
See, that's
you got to let me finish,
no,
Patty.
That's what you did before. You grafted the Sika balancing test onto his question about Arlupa.
Yeah.
That's what you're trying
This
to
is
argue.
what makes this so hard, right? But we have a job to do here, which is to balance, and I understand that. And in the past, in considering a number of cases like this, we have thought long and hard about the different ways, different functions, the different weighting of different functions, and how you create that balance, right? And we're going to do that here, and it's going to be hard, right? What I'm asking you is whether there's case law to support us doing that, and how we should be thinking about that.
I believe that there is, and that case law comes from the Sika jurisprudence. So Sika says, look, there are a range of public interests, again, assuming we're inherently beneficial. So there are a range, and it says, the Sika case itself says some public interests are more important than others.
Right.
There's a range. Let's just say you have to put it on a scale of 1 to 10. The case doesn't say that, but there's a range. Some are more important than others. And what we're suggesting in this very particular case, under these facts, is that the board can separate out the public interest from this proposed use. That's what we're saying. That if you want to, there are facts in this record sufficient to say, look, the students living together and that sort of religious expression, that's one sort of public interest.
Yep.
Pat, it's unfair for you to cut me off.
Only because you've already said that, and we've heard
He
it.
asked me a specific question.
Are you satisfied with the answer, Mr. Parlapiano?
I'm satisfied with the answer. Thank you.
Okay. All right. Let's move on. Any other questions for the planner?
Is it possible?
I feel that my client's due process rights are not being established, are not being fulfilled.
You've multiply established. We've let you speak on here for an hour and a half. You're getting plenty of time to speak. You're doing more speaking than the planner. Mr. Parlapiano is satisfied with the answer.
Can I ask a question?
Yes.
Is it possible under Arlupa jurisprudence to do what you've just suggested?
Yes, I believe so.
Do you have any case law for that?
Not in front of me tonight. I'll provide that as soon as possible. But the board can, the Arlupa test It deals with substantial burdens on religious expression. And I
Right.
believe that it's inherent in that test. The board could look at the uses slightly differently, if it so decides. It can make that, it's well within its rights to distinguish between these types of uses. The core use, the religious residence, and meetings, administrative offices, and other sorts of things that are readily available at other locations. I believe that it's absolutely inherent that there's a weighing process that's involved in determining whether there's a substantial burden. Because if you say the burden has to be substantial, you have to look to what you're burdening. And the burden here is one thing for the residents' part, and it's another for
You're
the other
repeating
part.
yourself, and you've made it very clear, you're repeating yourself. Okay. Other questions for the planner from this board, or for Mr. Skolnick? So now we have to let are we okay to go on, or should we take a break now? Are we okay? I would rather have the public question the planner if there are any questions, and then take a break at that point. That would be a
That shouldn't
natural
take very
division.
long. Yeah.
What? Well, she needs, that's true. Ms. Birkenwald gets a shot at this, and I'm sure she wants to speak. So are y'all ready to go on? Go on?
Take a break and just.
What?
Let's take a break.
Okay, we're gonna take a break, and we'll pick up with questions from Ms. Birkenwald. We usually break at 9 anyways. We'll be back in a few minutes. All right, we're back on after a few minutes break. And so at this point, Ms. Birkenwald, do you have any questions of the planner?
Thank you. I'll try to be very brief. You're familiar with the RESIS standards?
Yes, I am.
And are you familiar with the alternative standards under RESIS?
Not specifically. I know of them, but I wouldn't be able to articulate them specifically.
Well, RESIS does state that parking standards in RESIS could be modified, for example, in an area where there's public transportation.
That's correct. They're on the footnotes and also in a redevelopment area you can do that.
And 315 South Place is walking distance to quite a bit of public transportation, isn't it?
I had the opportunity to look at the notes, but I wouldn't be able to say the amount of mass transit that's nearby, and I don't believe there was any testimony as to the proximity of mass transit, so I could say that those alternative standards would apply. But again, I'm just saying...
Well, are you familiar with the village of South Orange?
I am familiar with the village of South
You
Orange.
know that there's a train station?
I understand there's a train station.
And it's walking distance to South Place?
It is within distance to South Place. I don't know how many feet it is. And when you go to the...
And there's bus stops?
There are many bus stops, but again,
Many?
when you
On
go
South
to...
Orange
when you
Avenue
go
and
to-
Valley?
When you go to the alternative standards, and you say there's mass transit, you have to be able to articulate and say on the record, here's the mass transit, here's the amount of mass transit. And I didn't see anything in the review of the notes, and I don't believe that there was testimony as to the alternative mass transit within the area, so that I could testify here as a planner that it would meet those alternatives. So I want to say...
Well, as a planner, you didn't investigate
I
the
didn't-
existence of mass transit yourself?
I acknowledge there is mass transit. I didn't investigate the amount, the proximity, and the extent such that the applicability of the alternative standards...
I can help here.
Right.
The attorney for the objectors has already indicated he doesn't believe RESIS standards could apply. And he doesn't believe RESIS standards would apply, so I'm not sure we need to go into whether or not they can be reduced.
Okay, I'm just responding to the
Excuse
questions.
me, Mr. Gemma, I'm talking to the applicant's attorney.
I'm sorry.
Now, did you look at the map of this property? How would you describe the shape of the property?
It's an irregularly shaped property, an interior lot.
A long and narrow lot?
It starts out almost like a classic flag lot and then opens up as it gets inside.
With a driveway. So
Yes.
doesn't that kind of indicate that there really isn't a whole lot of frontage on South Place?
No, there's not a lot of frontage on South Place. You're correct.
So that if cars park in front of the dwelling, they're not quite as visible on South Place as they would be on an ordinary street. Isn't that true?
I can see that they're not visible from South Place.
So parked cars in the driveway are not really a substantial detriment to the neighborhood because they're not visible.
Well, the problem is that if this were a regular...
Are they visible?
No,
But, Mr.
no,
Chairman,
let me finish.
the attorney is asking a question and then cutting off the witness
Right.
midstream.
Right.
So
I'm sure
he
she-
asked to complete the answer.
Hey, Ms. Birkenwald.
First.
Let him answer his question.
Right. And the answer is, of course they're visible to the neighbors. And the whole concern is, your question first was, are they visible from South? And the answer is, of course, it's a narrow street. They're not visible from the street. But to the neighbors, because there's a unique lot, they're visible from all the neighbors from their rear yards. That's one of the concerns that they have, that it's very visible to the neighbors, particularly to my client, whose rear yard basically is the front yard of your client, and all the parking is right there in front of their backyard. So in terms of visibility to the neighbors, yes. From South, not as much.
Well, the parking really isn't along the border of your client's property because that's where the driveway is too narrow to park.
No, then it goes around my client's property, and to the rear of my client's property is where most of the cars parked. In fact, those are all the photos that they had. That's where my client took the photos, and I think they were marked as exhibits, and I forget the exhibit numbers.
Would a number of planted trees between your client's property and the driveway be a condition that the applicant could do to mitigate the detriment?
Certainly, the more landscaping and the buffering you put in there has to help, and I think when Ms. Gruhl put together her report, she suggested a substantial amount of landscaping for light, and that's good. But what it doesn't do, what it can't mitigate really, and some of the concerns is you also have the issue of car fumes, you have noise when cars going back and forth. So certainly it helps. The more you put there is good, but does it do it the whole way? No.
Did you notice the approximate size, say, of your client's lot and the surrounding lots?
Yes, I did, as compared to the applicant. When you say
Correct.
approximate. Yes, and they're smaller.
What is the average size?
Those are smaller lots. I know your client has about an acre. And there, I would say they're 10,000, if not smaller. 10,000 square feet.
So they're more like, no, I think they're smaller.
Might be
than
smaller. They're
10,000.
smaller lots, right.
So they're maybe
right.
5 to 10 to an acre?
I don't know the exact size. If you do it, then I acknowledge they're smaller.
Are you aware that our planner testified that the average lot is about 1/7 to 1/8 the size of this property?
When you look at those immediately surrounding on all four sides, or just on South?
Well, I believe on Self Place and then on the two sides, the properties are approximately the same size. It's just at the other end.
They get bigger.
They get
more
bigger.
towards Montrose Park area. That's correct. And I concede that's right.
So if you had the equivalent of 7 lots instead of my client's 1 lot, you could have 7 dwellings there.
Well, I don't know if you'd meet...
Approximately.
Well,
not in this lot because you
right.
don't have frontage.
Right.
But in terms of density.
Well, I don't even know...
In terms of square footage.
In terms of if I just took the square footage out and I made this comply otherwise, then simply it would meet whatever the density requirements are, the square footage requirements. If you're telling me it's 7,000 square feet per lot, I trust you. So 7,000 divided by 43,560.
Actually, I think the minimum lot size is 6,000.
6,000. So it's 6,000 divided by 43,560.
Our planner did testify as to the fact that this density would allow 7 dwellings.
And I can't...
Mr. Chairman, I object to the question. There's no evidence in the record that 7 dwellings with a road could
No,
be laid out. I'm sorry.
I'm being
There's
misphrased, that the size of this property is equivalent to 7 dwellings immediately adjacent to it.
Objection to the question. There's no foundation that a 7-lot subdivision could be laid out on that property.
I'm not even suggesting that. There was testimony by Catherine Gregory, the planner, that noted that an acre of land would accommodate on Irving Place possibly
Elaine,
7 dwellings.
What's the point? You can't subdivide this property
No,
into
I'm
7 lots. We keep going around and around on this.
But you talk about
Elaine, let me talk for a minute. We keep going around and around on this with your planner, with you, again now, about something to do with density because this happens to be a big lot. It's a big lot that can't be subdivided. So I don't want to get into the fact that we can whack this into 7 lots, okay? Because it's a red herring. It doesn't apply here.
No, I'm not suggesting dividing it. I'm just saying that in terms of cars, if there were 7 one-family homes...
But there's not.
You might have 2 cars per home. All right. I'm going to withdraw that. Last question. Promise.
Okay.
On the ordinance, you note that the rear yard setback for this zone, and I have Schedule 2 handy. Right. It's small. I know I don't like reading it, but it's 16 feet, right?
You're making me do this now. Yes, 16. It's 16 feet with a footnote, and I think that's the heart of this. So you've got to look at the footnotes as they apply along with the amount.
All right, so it's 16 feet. And then the footnote, and if you don't want to read it...
Okay, I'll read it. It's appropriate.
Number 5, it's underlined.
It's underlined. but not less than 20% of the average lot depth, and that's number 5.
Is that kind of, that footnote could be read separately from the doubling, couldn't it?
I don't believe so. I think that, but the doubling is not in that section. The doubling is for the conditional use. And so when you go to the conditional use, whatever the setback is, the setback is. And then when it's a conditional use, you have to apply it.
It could be read the other way, though, that
In my opinion, as
20% would be the least.
He answered the question, Ms. Berkman.
All right.
And you
I
can bring
think
up
one
your
of the
point
board
in the
members
summation.
had asked even a better question, so I'm going to leave it at that.
Thank you.
I guess I'm not going to question Mr. Skolnick.
He testified more than I did.
I know.
Okay.
I guess we have the same issue.
Ms. Birkenwald, are you done with your
Yes.
questioning? Okay. Do members of the public have questions for the planner? Ma'am, come on forward. State your name and your address.
Pearl Avenue, South Orange. Do you know of any situation where a variance has been granted for a house of worship that is run solely by laymen? That is, there's no priest, rabbi, rector, reverend, imam, leader.
I'm not aware of any.
Are you aware of any accessory use to a house of worship that's used exclusively as a residence for college students in the absence of any ordained minister certified?
I am not aware of any in that kind. In my 30 years of experience, I haven't run across that one yet.
In your experience, can a house of worship be a house of worship if there's no officiating individual? By that I mean a minister, rabbi, priest, rector, reverend.
And the answer is it depends. You really got to go to the use. I think it's very difficult to try to establish that. But in some of the places where I have testified as a planner and as a lawyer represented, for some of the shuls where they have the Friday night prayers that takes place sometimes without a rabbi. So I have in fact done that. But it is very, very rare, and it's for a very limited use, and never in the context of, and oh, by the way, we're going to have 20 kids sleep here and live here.
Okay, thank you.
You're welcome.
Michael Gerstmann, 346 Terrell. I guess about the definition of a family, would it be a regular family where the members of the family change semester to semester? It might be very different during the summer months than during the academic year.
Right. Well, I think that's the problem, Michael. That's one of the things I didn't want to get into, but it was brought by the chair, and you bring it up as well. Does this even meet the definition of family pursuant to the Glassboro case or pursuant to the village's own ordinances? And if it doesn't meet the definition of family because it's not, Glassboro said one of the indices was you have to have a joint checking account, all throw the cash in there, and we'll go out grocery shopping. Well, it doesn't meet that indice because here you're paying money to a tuition to a third party. It doesn't meet the definition of family as defined by the borough's ordinances, but the borough's ordinances, like the Glassboro case, talked about permanency, and here you don't have permanency. Here you're rolling it over. So if this board, if I were testifying not on an application of a conditional use, but based upon the testimony given, as a planner, I find it hard if I was, and again, I wasn't here for it, I just read it. But based on that, I'm hard-pressed to find it meets that definitional criteria for family. And if it fails to meet that definitional criteria for family, then you have to ask, well, what is it? It's not a church. It's not a family. At best, it might be a boarding house or boarders. The village has an ordinance about boarders, and you can only have 3 boarders in any single-family residence. So if you ask me if this was a separate application, I don't even know if the residences meet the borough's the village's requirements I don't know if the residences, as described by the applicant, meet the criteria for family as established by Glassboro.
So it sounds like, from what you were saying before, is this correct, that the purpose of the zoning is to describe the nature of a neighborhood, and the parking regulations and other variances, or rules, are to prevent something just like this?
Well, the purposes of zoning are found in two places. The first place they're found is in the municipal land use law, and Section 2 of the land use law says, here's the purposes of zoning. It's A through, I don't know, I think it's T or S. Susan, how many numbers? I can't remember. I want you a lot of numbers. And they give all the different purposes of zoning. That's what happens when you get old, you forget these things. The other place you find the purposes of zoning is in your master plan. And there's a section in your master plan, goals and objectives. And your master plan of 2011 has goals and objectives. And the three that I think that are appropriate for this board and to consider in the context of this application are, one of the objectives are to protect the village's stable, diverse, and attractive residential neighborhoods. The second is to maintain the established, primarily residential character of the village. And the third, and the one that got me, is to preserve and protect the unique character of each of the village's many residential neighborhoods, including, but not limited to, those with a distinct architectural, historic character. When I went on the village's website, one of the cool things about your website, it actually takes you to the historic Montrose Park area. And I drove around it. And they're right. It's a historic. In fact, Mr. Lopos' property is identified as one of the historic ones. Across the street's the Don Bosco House, an historic one, right on Self. So if you want a purpose of zoning that's clear on a village website that says, here's the place, and that's an objective and purpose of zoning that you, the village, have articulated.
Is it plausible to have the 10 residence cars plus other visitors for any particular event park behind the house?
Well, you have to ask this. Is it possible? Sure, it's possible. But more importantly, does having that many cars parked behind the house for the services every other Monday night, does that preserve and protect the unique character of the residential neighborhood, including those with the distinct architectural historic character? And if this was a neighborhood of churches, maybe it does. Or a neighborhood of places that had big gatherings. But it's not. It's a residential neighborhood. So I don't know how you can there's a thing planners do, you try to justify and try to put it together, and you try to say, all right, this is how it all fits. How it fits. I think it does fit.
And the impact?
Well, I think the impact is it's on a historic residential neighborhood. And can you have that many cars parking there? And that's the heart of this. Going back at these meetings, does that have an adverse impact or not?
So if there are 20 cars coming out after the service or after a meeting, right next to Mr. Lopos' children playing on the sidewalk?
Well, I'm not even going to get to health and safety of both. Not only that, but you have to look at it. It's not only the safety of the neighbors. You have 20 cars packed in there at a service. Hope to God there's never a fire to get back there either. So it's the safety of the people back there, too, you've got to look at. But that's what we're not here about. It's here you're looking at the character and the content of the neighborhood. And does it preserve and protect it? Does it detrimentally impact it?
Well, thank you.
Okay.
We have other questions. Okay.
Thank you, Mr. Chair.
Well, I'm sure the neighbors have not finished their opportunity to make their comments.
Right.
But before we get to that, I had a couple follow-up questions for Ms. Birkenwald and possibly also Mr. Mocha. Is that it? Okay. Ms. Birkenwald, what was the testimony And maybe Mr. Mocha could answer this, about are there locks on the individual doors?
Mr. Grenchi, I believe, reported that there were no locks on any individual doors, and Mr. Moshe could confirm that.
I want to confirm that with Mr. Mocha. Is that the testimony?
That was the testimony he gave. There actually are locks, but we don't even have keys to them. They were just doorknobs with locks on them. If that's a problem, we can take those doorknobs off.
A little lock on the doorknob itself?
Like a doorknob that has just a keyhole in it. If that's an issue, we could take them off.
You don't have the keys to those?
We don't have the keys to those.
Okay.
We've never locked those doors.
Okay. The second question is, the frequency of meetings and the number of people and where do they gather? Again, was my recollection correct that you're proposing that these formation meetings are every other Monday, every Monday? How often again?
Every other Monday.
Every other Monday?
During the school year.
During the school year.
And you said like from 8 to 10 or something like that?
That's correct. 8 to 9:30, but I'm sure people leave there.
Okay. And how many people usually attend?
25 to 35.
25 to 35. Do you ever have, I know the mention was up to 40 at times. Are these the meetings that you're having off campus right now?
When it got up to 40 is when we moved it to campus.
Are there other meetings that you have regularly that involve people that don't live there coming to worship, to discuss the Bible, etc.?
Sure. Yes.
Okay. How often are those, and how many people go to those?
Never. Well, not on a regular basis. Numbers that big. The Monday nights are the regular meetings that would be that many people. The other ones would be the small group events. So a Bible study with 5 or 6 people, between 4 and 6 people in a Bible study. The staff missionaries gathering to pray. There's 8 of us. We would gather there to pray during the day. These types of meetings.
So the 5 to 6 people in a Bible study, how often would that occur?
Once or twice a day.
Are those people from off that don't live there?
It's usually a mix. It's usually maybe all of the men who are living there participate in these groups. Doesn't mean that they're all meet at the same time.
And then the missionaries meet there, you said how often?
I mean,
8 missionaries?
There are 8 missionaries at Seton Hall campus. And they will meet there at different times to meet with the students, to help lead one of these Bible studies. They'll meet there to pray. On a regular basis, there's usually at least one there every day to lead one of the Bible studies, to work with the men there, to mentor somebody. Somebody like Brother Jude, who testified, who was the religious brother, he might be there to have a counseling session, a one-on-one session with somebody.
And you don't have, and you're not intending to have Sunday worship with inviting the public in to the chapel?
That's correct. We've never done that, and we never intend to do that.
Let me ask you, this is for Mr. Mocha, but Ms. Birkenwald, obviously, as attorney, you could speak. You're having these meetings when they get up to 40 people, you're having them on Seton Hall, at Seton Hall. Are these, can these meetings be held elsewhere?
The larger meetings, when they get to be 40, they can be, and we've moved them to Seton Hall. A lot of these other ones could not be.
Like the missionary, the Bible studies?
The Bible studies. We have
meetings?
private space in the house dedicated for those small group meetings. We have private spaces for the one-on-one meetings. We have a chapel that can hold 24 people where the missionaries, we can have our own prayer and worship together.
How many people?
And there are non-Seton Hall students who live there. And so they cannot simply go on Seton Hall campus on a regular basis to have these meetings because they're not Seton Hall students. One-off, yes, they can.
So let me ask another way. These every other Monday night meetings, is it feasible for you to hold those at Seton Hall in perpetuity?
We could perhaps agree that if we expect the meeting to have over 25 or 30 people, that you would move it to Seton Hall, but if it's under that number, you would like them to see...
The chapel comfortably fits 24.
Okay.
Once you get, with standing room, you could easily fit 30 or 35. When it gets above that is when it gets too crowded even for us.
So then you would move
And then
it
we would
to Seton
move
Hall.
to Seton Hall. Any meetings bigger than that, we would always have at Seton Hall. So we do host much bigger programs. The retreats, I don't know where the testimony came from the other attorney. I think we testified we will not have retreats there. We don't host retreats there. We host retreats at a completely different center.
I believe there was testimony that when the Salesians lived there, they
That was
had
probably the
retreats.
source of confusion.
That was the source of confusion. You haven't yet.
We don't have retreats there.
How would we enforce you just having 24 people there and not having retreats, revivals, striker rock concerts?
We've been there since September. I don't think there's been one noise violation or noise complaint even.
Well,
I
understand that. That wasn't my question, though. How are we going to enforce that?
Let me just ask another question, not to be, if it wasn't granted and we remained there as a single family, and then as a single family, we were limited by building code and we had 20 people, 25 people living there, how would you limit if those 25 people wanted to have a gathering or a party or a get-together?
Mm-hmm.
We live in South Orange. That happens all the
Well,
time.
they would call the police. The residents would call the police. On the other hand, if you're a religious organization, it gets to be problems of limiting, unless you all would stipulate that you're going to limit the amount of people that are gathering.
I mean, it sounds like cars are the big problem. And so we're happy to limit even the number of residents with cars who are living there even to 10. So we originally said 12 students. We can just simply say we'll never have more than 10 people living there on a regular basis who have cars.
And you have an agreement with each student that you
Yes,
live
so
with,
we
so you
could
could put in
easily-
that agreement that...
Since we've been there in September, we've never used street parking.
Well, because I see you've got 13 at least on one occasion, all lined up on the street on the driveway.
That's correct.
You originally said that you would limit it to just 12 people, period. Now it's been backed off to 10 people with cars. That means you could have many more people there without cars.
Well, we just think limiting, it seems like the issue is cars, so we think that having a limit on the number of residents cars would control and mitigate any detriments the most.
Cars are an issue, but I think it's also residents, too. You initially said limit it to 12 residents and one supervisor, and now you've backed off on that. Yes, it is an issue of cars. It's also an issue of how many residents there. You have more and more residents there, more likely for parties, noise, etc. I want you to think about that.
You're right. I think what happened was having learned about building code and realizing if we remain there as a single family, that we could have 20 people living there, made us question, do we want to limit it to 12 if we could have 20 or 30 people living there without the variance?
Mr. Can I ask a question?
Sure.
I'm kind of confused all of a sudden.
It took you till now to get
Yeah,
confused?
but I'm kind of confused now because
I'm impressed.
he said something a while ago that I had to write. You have non-Seton Hall students there.
That's correct.
And I'm saying to myself, well, why would you have non-Seton Hall students there? Are they going to a religious institution other than Seton Hall? And what do they do in the day? How do you select them? Why would somebody want to come and live in South Orange just to...
Because
just
we're
to be
there, because St. Paul's Outreach is there. So
Because
they're students at other colleges.
Oh, so you're saying So you have other students from Rutgers, you have from NJIT, or do you sure they
Montclair.
but do they go to college?
Yes,
Or
they're students.
They're
They're
all
full-time
going to. You
students.
sure about this?
In fact, you now have one student that takes the train to, I think, Hoboken, or I forget if it was Hoboken
We had a
or
student, yeah,
Newark.
he
every
graduated
day.
this year, but he went to NJIT and took the train.
Do you have any students there that don't go to college?
Right now, no. We had
Right
one,
now, no, but one could, but you could.
but one
All
could.
right. So he'd be hanging out in the house for the day.
We would never let someone live there who wasn't in school or who wasn't working.
Okay, all right.
Could they actually stay there with 20, unlimited number of single-family, what they call single-family, if this board didn't recognize them as a single family?
Up to the code allows, they could occupy.
The building is 7,000 square feet. There are the equivalent of 14 bedrooms. They're
Right.
not always used as bedrooms. Some are used for study rooms, for Bible studies.
So-
But the code would allow 20 people.
Even
Right,
if
so
you're not a
let's-
single family, though?
Let's hear from Susan, if it's okay. I mean, I'd rather hear from our planner than the applicant at this point on that question. We've heard
Well-
certainly plenty from the applicant's planner and attorney, or actually the opposing planner and attorney just a little while ago, so.
No, in terms of the code and how many residents they could have, I think that Mr. Dwyer answered that. There's specific code requirements. I do not know what that number is. I know that it's a large house. I know that, or structure. I know that there appeared to be multiple bedrooms, but I don't know how that translates in terms of code and how many.
My question is more of zoning. If it's not considered single-family, in other words, let's make it hypothetical. Let's make it clear, much more clear too. Let's say it was just unrelated people, not in any religious, shared religion, just living there, students living there, 20 people. Would that be allowed there in that house if they're not a single family?
If they didn't, for example, share the same checking account, it seemed to be the distinction that was made just a little while ago. I mean, it's the one thing that doesn't apply here.
Actually, can I just...
Well, let me just hear from the planner about this, or our attorney, either one.
Our zoning officer, unfortunately, is not here, so I'm going to
Pass on that one, sure, okay.
expertise.
I mean, just on that issue of the checking account, I mean, and again, the witness is back, so it was my recollection that they paid in, but then they were given money out of that account, actually, to go shopping for their food. So it almost was the same thing as the Glassboro case.
And just if I could clarify, there is a common checking account. The students pay in together. One of the students living there has the checking card, the MAC or the ATM card. So there absolutely is a shared checking account. It's not in the name of St. Paul's Outreach. This last year was in the name of Craig Johnson, who was a student at Seton Hall. And so the checking account was in his name. All the guys paid into it collectively, the same amount every month, and they went food shopping from that account, and all the sundries and everything they bought came from that account. So there is a shared checking account.
Thank you.
And that was my recollection of the testimony as well, and that there was shared housekeeping
Absolutely, we
duties.
do
There
not.
was
I remember all that.
a key
Yes.
component. So that's what I recollect as well.
Okay.
What's going to happen over the summer? Are the kids going to stay, or what are they going to do? What's going to happen over the summer?
Some of the kids stay, and some from out of state decide to go home.
All right, that's all the questions. I have.
If I may,
Yeah, Mr. Dwyer has a question.
I just wanted, if I can, ask a question about one of Mr. Chairman's questions had to do with missionaries. You said there were 8 missionaries. You said there were 8 missionaries. I think the previous testimony was that there was one missionary who was not a student who lived at the house, correct? So who are the other missionaries?
They're full-time missionaries with St. Paul's Outreach on Seton Hall campus.
And they reside on the campus?
Most of them live in the dorms, the residence halls on campus. Some of them, commute from home. And this would be their work, their job.
And when you said there were 8 missionaries who meet, do they meet together as the 8 missionaries? Or do they only meet one-on-one with certain students?
Both. Their main work happens on campus. They're missionaries for Seton Hall campus. But then they would come to the house to use the house, to meet with a student, to meet one-on-one with a student, to lead a Bible study, or to have the whole staff come together for staff prayer.
Thank you.
Do you find parking to be a really big problem during the day?
Do we need to open it up to Ms. Birkenwald?
All right.
Providing, we've already established that you all don't think it's a big problem. And that's clear. What that answer will be there. Do we have to allow the public to ask questions of this limited testimony? We
Yes.
do? Okay. So does the public have any questions on this limited testimony? Come on forward. Over here first. This lady is going here first. Come on.
My name is Leslie Jones Thomas. I live at 366 Terrell Avenue, and South Place comes directly towards my house. This is my first meeting, my first exposure to this issue. Essentially, based on what you're saying in terms of the interaction between the missionaries and this residence, isn't essentially this residence off-campus Seton Hall housing?
Absolutely not. We have no agreement with Seton Hall. We're a completely separate organization. We're a separate religious organization. We are a separate 501c3. We're a separate everything. Seton Hall has asked us to come there to provide our religious programming on campus, but we're two completely separate. We have non-Seton Hall students living there.
And when you say you're completely separate, does St. Paul's Outreach own the house or lease it?
We own the house.
Okay, and is St. Paul's Outreach a 501c3 organization?
Yes.
And in contemplation of this expansion of the use of this single-family residence, is there a possibility of a future application for abatement of property tax payments?
I don't know if I need to answer that.
It's not. Well,
this is a zoning.
Look, I want to go to. I don't. Look, I share your concern, but I think it's irrelevant for the purposes of this board. Nonprofit organizations don't have to pay taxes. Go talk to your legislators. Is that correct, Mr. Dwyer?
Yes, it's not a zoning issue, Mr. Chairman.
Yeah, it's a larger issue. It's not a zoning issue, and so I really want to cut that off because we can't. There's nothing we can do about it.
How long has St. Paul's Outreach been at this location?
Since September of last year, since September 2014.
And isn't it correct that during the summer, St. Paul's Outreach had a very large meeting in the middle of the summer with over 50 individuals coming into your location?
This current summer?
Yes.
No.
Okay. I have no further questions.
Well, you took ownership this fall, past fall.
Yes.
So you weren't there the past summer.
Correct.
Well, you did have some meetings there previous to your ownership. Didn't you represent that earlier in previous testimony?
Yes, we never had something over the summer with 50 students. We used to borrow the house from the Salesians. They used to let us use it.
Okay, but you never
during
had
the
a
school
meeting.
year. Correct.
Okay.
All right. Come on forward, please.
Deborah Pittman, 351 Terrell Avenue. The cash card that you were referring to in the name of the student, was that used to pay utility bills and other household expenses, or was it just for food and toilet paper, paper towels, and things like that?
The latter, for food and toilet paper and things like that.
Thank you.
Have other questions?
Clarence Jones, 321 Irving Avenue. There's something that keeps ringing in my head that I don't fully understand. About 3 months ago, when I asked the question, what were we discussing, there was some discussion about how the house went to 16 bedrooms or more.
Do you have a question for the witness?
Well, if he can answer that question.
That wasn't a question. What's the question?
Sir, the position here is you're to ask questions of this recent testimony by this
So you're not open
witness
for questions to the board yet?
No.
Okay, I'll wait.
Okay, other questions based upon this limited testimony given tonight by Mr. Mocha? Okay, thank you.
Thank you.
So now we get into further comments. You can come right back up. from the neighbors.
The point of my question is based on the discussion tonight. I've heard from testimony from the
I didn't testify.
the gentleman here and the board members that one of the primary issues for this board and responsibility is to preserve and protect the characteristics of the neighborhood. So my question is, which is the second time that I've asked it and no one's really got to that answer yet. How did that unit grow 16 bedrooms, which I think represents more than 20% of its overall structure, and get the approval from this board without the community knowing?
So the answer is the applicant came into the building official and asked for a permit to do an expansion onto a house that didn't require a zoning approval at all.
20%?
There's no percentage requirements
Well,
for
I put one bedroom on my house and I had to go to the zoning board.
Well, maybe you had a coverage
Well, this-
problem. This is obviously a large house. So
as
there's no
part of-
conspiracy behind this. It's just there was a permit that was granted for
The question was how,
an
not
expansion to a
conspiracy.
single-family house.
The question was how, not conspiracy.
Well, I
If you're
just
saying
answered
that
your
as
question.
a resident, if you're saying as a resident, I can't ask you a specific
No, I
question
told you the answer.
that I'm not aware of without you applying to me.
Well, you've asked
that
it
it's
more
a
than once.
conspiracy.
You've asked it more than once.
That's your terminology, not mine.
There was a permit granted. We have a certificate of occupancy that was submitted as part of the original application that was issued in 1991. November 4th, 1991 specifically. Certificate of occupancy was granted to the Salesian Society for a modular addition to an existing single-family house. Now, the way the zoning works is that if your addition doesn't cause any nonconformities with the zoning, you don't have to go to the planning board or the zoning board. You could just get a building permit.
And that's my point. If you're saying to me that one of your primary roles was to preserve the
No,
characteristics.
you're not-
Let me finish.
No, let me finish.
Well, let me finish.
Okay, you finish first.
Okay, thank you. Is to preserve the characteristics, as this gentleman said, of the neighborhood. I would like to know how many houses in this area have 16 bedrooms.
The number of bedrooms is irrelevant. Just because you don't like the answer doesn't mean it's not the answer, okay? So just listen to now you can listen to what I have to say, okay?
I haven't opened my mouth.
If the building meets the bulk requirements, setback, coverage, height, there's nothing in the zoning that says you can't build a 16-bedroom house. Now, none of us here were on a board in 1991, and this project probably didn't appear in front of the board because it was a as-of-right application. Now, the problem is that it was reviewed as a single-family house. Nobody noticed that there was a chapel built, which would have, to me, raised the question as, why is that still a single-family house?
Or maybe the zoning officer thought it was for the accessory to the residents themselves.
I mean,
but it didn't go for a variance
Right.
to this board.
Well,
is that answering your question?
Well, in a way it is, and in a way it isn't. if you're saying, now, if you don't like the question, what's your point? You see?
I don't know.
That's a
We've
double-edged
asked
sword.
this question at every meeting, and we've
And
answered
you
this
haven't
question.
answered it.
We
Here's the
have.
point.
We've-
Here's the
we've
point that I'm
answered
making.
it.
Here's the point that I'm making, and then I'll sit down at your comfort, okay? Because I'm obviously making you uncomfortable.
I just get
Okay.
tired of having the same
Well,
answer.
And the point is, if you're telling me something has been approved that should not have been approved, then why haven't you done something about that?
Did
It's
anybody
not-
say it shouldn't
it's
have been
not the zoning
approved?
board's job to do that. Okay.
Did you say it should not have been approved?
I said it may have raised a
The
question.
evidence we have from the certificate that you can go check for yourself if you bother to go down there is that it was an addition to a single-family home, like Mr. Don just said. So in other words, my interpretation of that, it never came to this board because it was an addition to a single-family house. It doesn't go to a board. You could have 30 bedrooms if it fit within the bulk requirements, lot coverage, setback, etc. And so it just didn't come up as a question of whether it's a house of worship, because perhaps the zoning officer didn't think it was. I don't know.
It was
And
24
what
years
it,
ago.
what it, look, what it does get to is Mr. Skolnick's concern, and I appreciate his outlining of these issues. He did it better than we've done. I don't necessarily agree with his, on everything, but he outlined the issues nicely about that this is not an approved pre-existing condition, in my opinion. It just wasn't determined that this was a house of worship before. It's either uncertain or viewed as still a single-family home. So
I would say it's, based on the documentation we have,
it's a single-family home. That's the closest thing we have. So I would agree with that, and he brought that issue to the fore, and I appreciate that. Do we have any? We have other comments.
Michael Gersman, 346 Terrell Avenue, and I hate public speaking. I guess I would say, to start with, I think the audience is maybe not always behaving well because I think this doesn't fit in the neighborhood. And I think pointing out that if there's plenty of, as the planner at the previous meeting did, with moving things around, it's this, it's that, and aren't you glad that there's not a soup kitchen here or unwed mothers, is not always the question. But if there's plenty of public transit, then why do you need so much parking? And I think this doesn't fit in the neighborhood, and I think there are rules why you can't fit 7 houses on this lot. But if you're having 14 people there, that's like having 7 houses there. And there are parking regulations so you don't have 20 parking spaces on somebody's in a private house or in a house of worship that's in so many people's backyards. If we're going to have 14 people living there, that's like having 3 or 4 households. And 3 or 4 households on Terrell and 3 or 4 households on Irving, because these are the, what everybody's backyard is. And everybody's allowed to make a little bit of noise. At their home, they're allowed to change their oil. They're allowed to have some overnight guests. They're allowed to have some guests that stay late at night. Everybody's allowed to come home at 2 in the morning sometimes, or leave early in the morning and double-click their car alarm, so it makes that noise, or their alarm goes off. If you're having 14 people living there with 8 cars or 10 cars, with everybody being in so many people's backyards, that's not fitting in this neighborhood. If you're going to have, even though the current clients are quieter and I think they're going to abide by the rules, that doesn't mean that their guests are, or that their guests aren't going to accidentally set off their alarms, or that the summer people are going to follow the same rules just as well and not back out of the driveway. Or if you, our neighbors, grant this variance, and there's a house that has 14 bedrooms and 20 parking spaces, that the next owners of the house are going to follow all these rules. They're not going to back out. They're going to maintain all the shrubs that do the privacy. And that's what we're going to have to live with if this house is given a variance, 14 bedrooms and 20 parking spots. So there are reasons why there's parking laws and ordinances and zoning regulations, and no matter how you slice it, this group does not fit in any of that. And this is smack dab in the middle of 15 people's backyards. And all those cars coming in and out are going to go right past the few houses on Self. When we have our annual party, Self gets closed. It has the lowest impact. It's not really even a spruce street. There's no reason for anybody who doesn't live right there to go on it. If it's going to be trapping 10 people, 14 people into their homes to have it closed, that's going to double the number of people that are impacted. It just doesn't fit. This is a small neighborhood. It's going to double the number of people coming in and out of that driveway, right between those houses on Self. And I think that's why people are upset, that this is the reason for zoning and for all these ordinances, is so that you guys can say no to something that completely doesn't fit. And I know you have certain, only certain bases in which to say no. I think that's what your job is to say, this doesn't fit this doesn't fit that. And I would like you to keep that in mind when you're looking at these, the request to approve changes, that it doesn't fit. And that's why people are so upset that we're about to be getting something that doesn't fit in our neighborhood. To have 20 cars slamming their car doors, opening their car doors, rearranging their cars so the person who's in deepest can get out at 10 o'clock at night when everybody has to leave. Or, it's not fair to the residents, too, for them to have to not be able to make noise, have a party. And there are going to be enough people who are going to have guests at any particular day and night, which is different from OHEB, where if their religious expression requires occupying a space 24/7 in so many people's backyards, and it's not on Scotland, it's not on South Orange Avenue, it's on Self Place. So that's different. That's not the same for 24/7.
Hi, my name is Adrian Whipple. I'm at 355 Terrell Avenue. And I love to speak publicly. I just don't do it very well. I've been a little bit surprised about the process. It's the first time I've sat in on one of these. I think there's been a disingenuous communication to the neighborhood, as I think the attorney pointed out earlier. I originally thought this was about a couple of parking spaces. I didn't even know it was about use until at least the end of the first meeting. And that was followed up by what I would call disingenuous testimony from a traffic and parking analysis that didn't even mention the traffic impact on a residential neighborhood with 20-plus children by bringing them going from 0 to possibly 12 or 24 high-risk drivers into that small area. I don't know how you can make a decision without having the traffic impact that'll have on small children and on families in basically a 2 or 3 block area. It doesn't make any sense. I also, it was also followed up by what I would say is more sort of disingenuous commentary from a planner whose facts were his officer demeanor in many respects, having no factual basis for much of her claims when she presented her testimony, resorting to scare tactics, which I think I heard some more of this evening, about soup kitchens and halfway houses, or maybe we'll just have 20 or 30 people living in here instead of doing this. And that's what I heard this evening, right? And so it seems like a lot of the basis of having this in here is the good of the community. There's some basis about how this is supposed to be good for us. Yet I feel deceived in many respects, and I feel the process has been manipulated from day one, and I realize we don't have power over what came before us. We only have power over what's before us now. And I think there's been manipulations and deceptions along the line, the whole line, right? And how we got a chapel back there and to what's being proposed now. I guess, I've heard a lot of lawyering going on, particularly tonight, and I guess that's all fine and well as long as everybody's lawyered up. But when you get, one thing I know about lawyers is one presents some case study and then another brings some other case study, and then there's some argument, and somebody has to boil it down to the end, to what the issue is. And, I think the issue is, as many of us have already stated, and I think you get that message, it just doesn't fit. This doesn't make sense. It doesn't represent the community. It doesn't represent the taxpayers that are there. There's in my estimation, between $10 and $20 million worth of property value that's on the line. The investors that have invested in that property value are very interested in what's going to happen if a dorm is put right there in the epicenter of their block. It doesn't make any sense. And that is a dorm. This is no more a house of worship than my single-family home. This is a dorm. There's no two ways about it. He's got students from this school, students from that school, and who's going to enforce that they're even students? It's based on their word. That's what we're saying. So do I trust these folks? Absolutely not. Based on what I've seen and what I've heard, there's no trust. I don't trust people who try and scare me into the lesser of two evils, and manipulate this process. So, disenchanted is one way of putting it. I don't think this is I think this is a bad approach. I think it's a bad set of options. But I don't see how there's a yes. I don't see how there's a yes in here at all to this variance. And if it's going to have to go down to a single family with 20 or 30 people, as borders, I'd rather face that issue than have to face 2 years from now when they sell it to Seton Hall or do whatever it is they're going to do, just get kind of whatever scope creep they want to get. I just am appalled. I don't get it. So I don't believe that they're going to do as they've presented. I don't think that we're going to have this small family live in our backyards. And I hope the board gets to know. And that's all I have to say.
No. You can raise your hand like everybody else, Mr. Skolnick. This gentleman, I guess, is he allowed to talk at this point? You just barge on up, right on up to the microphone. You'll get your chance. Just have a seat. This gentleman's coming next. Does he get a chance? He's the attorney for the. Does he get to make comments?
In public comment, either his client or Mr. Skolnick would have an opportunity.
They do?
Yeah.
Fine. Okay. This gentleman will go first.
Hi. Thank you very much. Charles Mahoney. I live at 340 Irving Avenue. First, I wonder if I could enter some photographs into evidence again just to show the impact of the parking from my property's point of view. I know Mr. Lopez had his attorney do that earlier. I do have copies that I believe will cover every member of the board. It shows the view from several different angles from my property. Am I allowed to do that at this point?
Yes.
Why not?
Yeah.
Yes.
Yeah.
Okay.
You should give Ms. Birkenwald a copy too.
Can you tell me what it is that you're offering?
Excuse me?
Can you describe what it is?
The photographs that I have there, the first page just shows the impact of the parking situation at Self Place from two different views from my house. The first page shows from the second floor.
Just how many pages are there?
It's just 2 pages, that's all. 2 pages and 4 photographs total. And on the second page, there's...
Does it have your address on it?
Yes, it does at the very top.
All right.
And on the second page on the bottom, it just shows an impact, which I'll get into with some of my comments here, based on the paving and the reduced setback that we have right now, a flooding condition that's on my property, and I understand it's on several of my neighbors' properties as well in heavy rains. And I can talk a little bit more about that as I go through my statement here. I apologize. I'm going to have to read some of this here. I don't have it all memorized. But I want to go over about 3 points that I have, my objection to this variance, some remedies that I feel that if anything at all were to go forward, we would be required. And then I do want to make some comments about what I believe the goal of St. Paul's outreach is in the future and some information there. Just something additional. Mr. Motion mentioned that they're separate from Seton Hall University, and that may or may not be true, but based on the 2014 financial report from St. Paul's Outreach, they do get funds. The New Jersey chapter is funded by Seton Hall. They're listed as a financial supporter in their document. I have no information on the amount of money there. So as far as my objection, based on the photographs here, the volume of vehicles parked in what amounts to a parking lot behind my house, it's visually offensive to me and my family and negatively changes and impacts the character of the neighborhood. I believe that this negative impact will ultimately result in the reduction of property values in the neighborhood. The volume of traffic entering and leaving 315 Self will create hazardous conditions for the numerous pedestrians who walk their dogs, such as myself, and for a lot of the school-age children who live and play in the area. And the parked vehicles present a clearly visible eyesore to the adjacent homes. So the view that I have is very similar to some of my neighbors on the Irving Avenue side for sure. One of the issues that I believe there's a lack of defined and limited parking spaces, which enables and encourages the parking of many more vehicles than what the application requests. Early on, I believe it was the first meeting, the applicant stated that they did not want lined spaces because they felt it would look too much like a parking lot, and I'm paraphrasing there. The traffic engineer, when questioned, stated that typical parking spaces are about 25 feet long. But when I questioned the traffic engineer, he admitted that without lines, it would be possible to park as many as 22 vehicles along the parking lot and driveway, which I feel is clearly too many cars. The applicant has also stated a desire to hold large meetings at the property, which we know, and I'll go into something that I read through St. Paul's Outreach as well. And that's going to result in large numbers of vehicles. And without lines, there's really no way to control that. There's no way for me as a resident to call up and say there's too many cars there. There's no proof that there are too many cars because there's no lines. In addition, the grading of the property causes a lack of drainage, and the proximity of the paving to the adjacent yards causes runoff. I also believe that there's no practical way to enforce, as we've stated before, the maximum number of residents that might be housed in the property, either now or in the future, regardless of what St. Paul says they're willing to concede to at this point, and especially given the size of the structure and the number of potential bedrooms. Furthermore, and I'll go into this a little bit later, the organization's stated goals are to increase membership, and they cannot do this without housing more students. So as far as the required remedies, if anything is to go forward there, whether it's a single-family house or something else, we're going to need to improve the drainage. The setbacks need to be enforced, and they're going to need to install some sort of drainage system to take rainwater away from that area so it doesn't get onto my property and my neighbor's property and flood my backyard, drain that somewhere out to a storm sewer. I'm not a drainage engineer, but I'm sure that's not a difficult thing to do. Parking. I'm suggesting, much as when the Salesian brothers were there, that we limit parking to a maximum of 4 vehicles, with 2 in the garage and 2 in the outside spaces that are currently marked as spaces 8 and 9 in the applicant's parking plan. The applicant has previously stated that parking is available at Seton Hall, which is within walking distance. In addition, Seton Hall can provide jitney service to and from campus and in inclement weather, so I don't think the restriction in parking is going to be too onerous for them. I believe that parking spaces, whatever is there, must be clearly marked with lines at the prescribed sizes to enable parking enforcement. Without the lines, you can't call an enforcement officer over. I don't see there's any way you can limit that. We're going to need visual buffers consisting of landscaping, trees, shrubs, that's outlined in Section 92-213 to require and limit the visibility of any vehicles and structures on the property. Now, as far as what St. Paul's Outreach is trying to do, we've already established that they're a nonprofit organization. They've got mission centers and chapters in many campuses with members from many colleges and universities. And it's important, I think, to note that they refer to their students there as members. And specifically, they talk about St. Paul's Outreach missionaries and members on page 10 of the report. Household members also participate in the SPO formation, and some of these students even become extended household members. The 2014 report goes on to talk about their recent purchase of this property at 315 South Place. It says here, on September 24, 2014, SPO New Jersey purchased an amazing new house less than a quarter mile from Seton Hall University campus. The 7,300 square foot home, which includes a chapel, more than 10 bedrooms, and an acre of property, will be a center for programs with the potential to serve more than 17 colleges and universities within 12 miles of the front door. The current focus for SPO's 12 staff members in New Jersey is drawing new students to the ministry through 26 small groups. In my view, it's clear that SPO plans to expand membership, as outlined in the 2014 report. Their statement that more than 10 bedrooms exist points to as many as 20 students being housed on the site, assuming 2 students per bedroom. So I don't see that they're going to limit this to 12 people. This is something that's intended to grow. Now, I believe there's a possibility that there could be a change in classification. There is subsection 92-213, which covers lodges, fraternal organizations, nonprofit corporations, and associations. And they would, if they were found to comply under that or fit that, then there's a whole slew of things that they would have to conform to, in addition to or including notifying the town who the officers are, including names and addresses, the full particulars of the operation, proof that the proposed use and the proposed location will not adversely affect the safety and comfortable enjoyment of property rights or otherwise adversely affect the value of adjacent properties, that the design of any structures erected in connection with such use, and so on. You can read this yourself. I won't go through the whole thing. The last thing, though, is that no living quarters or sleeping accommodations of any kind shall be permitted on the premises occupied by organizations specified in this subsection. So I think really the only way to rectify this situation and make it fit within the neighborhood is to limit the parking, as I said, to about 4 vehicles, which would be consistent with what the Salesian Brothers had there before, and maybe to change the classification of this and say that this is a nonprofit organization, which it is, and therefore they're not allowed to have any overnight residence in the property. So that would alleviate vehicles on most of the weekends, and at nights they'd only be allowed to use it during the day for meetings. That's it.
I appreciate this. You don't buy the argument that this is a religious organization?
It is a religious organization. I don't buy the argument that it's a house of worship, but I think it's a religious organization very much in a similar fashion as something like the Knights of Columbus, which is also a fraternal organization. It's for grown-ups. I don't know much about it, but they do have formation meetings in Knights of Columbus. They do other things as well, but I think it's more along those lines, but geared toward college students.
Another question. Another resident brought up the issue of flooding. Why is it you assume that the flooding is caused by the applicant's property as just opposed to low-lying area in general?
Well, I think my property became a low-lying area because if you look at the grading, and again, I'm not a landscape engineer or a landscape architect, so it's hard for me to say, but you can see from my property that the paving is elevated above the level of my property, which is causing the runoff. And in discussions with some of my neighbors, they're going back many, many, many years, that when that was added, that whole thing was regraded. And of course, when you're grading a driveway, you're going to want to grade that away from a house. So I think that's graded away from the main residence, which is grading it actually toward my house.
Okay. All right. Thank you.
Thank you.
Can I ask you a question about your photos?
Yes.
The bottom photo on the second page has an arrow pointing to what appears to be standing water.
Yes.
Is that view the same view as the first picture on the front page?
It's essentially from the same angle, yes.
Okay.
Thank you.
Thank you.
Yeah, you're going to make him wait.
Deborah Pittman, 351 Terrell Avenue, where the St. Paul's property abuts my rear yard. There's a cement, ridge, a cement curb about 6-8 inches high, so water does run off. But the back of my yard is very low, so it doesn't come towards the house. We've had some commentary on Glassboro, and there's been a big focus on shopping together and eating together and living together and praying together. In Glassboro, there's 2 big distinctions. One, the house was purchased by family members for a son and brother who had a preformed group of 10 fellow students, friends, who wanted to live together through college. It wasn't purchased by a not-for-profit corporation and populated by students from various campuses that are recruited for evangelical purposes. I think that's a significant difference, that it was a core group who were formed to stay together, who agreed to stay together for a period of their college education. Second, in Glassboro, the Supreme Court of New Jersey overruled a specific ordinance that was enacted specifically as a reaction to rowdy parties held by Glassboro University. There is nothing that I can find about our definition of family that shows it was enacted to use zoning as a policing method. And if you look at the Glassboro decision, it specifically says the borough amended its zoning ordinance, apparently in response to rowdy weekend celebrations by Glassboro State of College students. Our definition of family, which was enacted about the same time as the land use regulations and the statement of purpose. In the statement of purpose, there's nothing about using zoning as a policing measure. And I think that's a very important distinction when evaluating the Glassboro decision. Finally, in 1972, the United States Supreme Court, in a decision that Glassboro declined to follow, wrote, "A quiet place where yards are wide, people few, and motor vehicles restricted are legitimate guidelines in a land use project addressed to family needs. This goal is a permissible one. The police power is not confined to elimination of filth, stench, and unhealthy places. It is ample to lay out zones where family values, youth values, and the blessings of quiet seclusion and clean air make the area a sanctuary for people." And that's a decision called Belterre, and it's 416 U.S. 1. In conclusion, I don't see how it's a house of worship. There is a question whether our ordinance permits religious buildings or houses of worship, which I think remains unresolved from the last meeting. And I don't see how people who are recruited into a situation, even if they're living as a household, constitute a family.
Thank you.
Mr. Skolnick, you want to come on up?
There's a guy in purple back there. Another member of the public behind him.
In my zeal, I found the case that Mr. Parlapiano was looking for. It's called 636 Inman versus Township of Woodbridge, New Jersey Appellate Division, decided February 5th, 2014. It's a case dealing with a child care center in a residential zone in Woodbridge. It was a denial by the Board of Adjustment. The Law Division upheld that, and the Appellate Division agreed. And the court specifically looked at this issue as to whether the use could be satisfied at another location. And I'll read the paragraph, since it was asked about specifically. Our conclusion does not mean, however, that the degree of need in the community is irrelevant to the board's consideration of the application. The zoning board may, as it did here, consider need in relation to other factors in balancing the competing interests and factors required by SECA. It can give less weight to the positive criteria established presumptively by the inherently beneficial use, and here it is, if in fact similar facilities in the community meet the public's need for that use. Let me read that again. If in fact similar facilities in the community meet the public needs for that use. So as we argued, and as Mr. Parlapiano asked for, I have a case that I believe essentially stands for the proposition that the board can consider, amongst all the facts, whether the use can take place somewhere else in the community. The case is 636 Inman v. Township of Woodbridge.
Thank you.
Somebody, come on.
Ben Vitale, 331 Terrell Avenue. So despite my exuberance to participate in the conversation, I'll first say that I really appreciate the board's time and attention to this matter. I know you're trying to make the right decision for all concerned, and I appreciate your time. The question before you is whether or not to approve this variance to call this property a house of worship and to vary a couple zoning rules to make that happen. And I think you've heard tonight from our witnesses that you have a sound basis for denying that variance. There's a couple of reasons, a couple of things I think the board's particularly worried about. First of all, one of them is the case made by the applicant repeatedly and its witnesses, and I think has on occasion actually convinced the board and even sometimes convinced the neighbors that it's in our best interest. We may not like this, but the alternative is even worse. I'd like to suggest that that's not relevant. the balancing test that you have to do when you're deciding a zoning case is between the best interests of the status quo and what would happen why is it better to actually grant the variance, right? It's not about the bad things that will happen if you don't grant it, okay? It's about the good things that will happen if you do. And so I think you should really put a lot less weight in the neighbors are willing to take the risk and we'll deal with the single-family problem when it comes. We really don't want to have the house of worship situation coming up. We don't want the board to give its stamp of approval to this 20-year-old problem, which, more or less, because of the history, is in a sort of pseudo-legitimate situation. And I think the applicant desperately wants that stamp of approval so they can have their meetings, so they can conduct their missionary activities, so they can and so they don't have to pay taxes. That's right. And I think it would be a grave mistake for the town and for the neighbors to grant that. Now, the other thing that the board is really concerned about is the legal situation. I think common sense tells us that this is not a house of worship, and a house of worship doesn't fit in this neighborhood. And common sense tells us that this is not a single family, and that a dormitory doesn't fit in this neighborhood. But legally, you're concerned about the Glassboro case, and you're very concerned about Arlupa, and because you're looking out for the town. You don't want to expose the town to unnecessary litigation and cost. And, as a taxpayer in this town, I really appreciate that. You're doing the right thing to worry about that. But we've heard from the witnesses tonight that that's really not a concern you have to have. There are perfectly legitimate reasons to deny this variance and to not put the seal of approval on a house of worship for this property. It's a residential use, and it's a residential use that doesn't meet a lot of the requirements for a single family, and it's a residential use that doesn't meet the house of worship standard. And more properly, there's nothing compelling you to grant this as a house of worship. We have rules in the ordinances of the town and the state planning laws that you heard from our witness tonight that show that the setbacks aren't there. And that setbacks aren't just technicalities, right? There's common sense behind those things. Setbacks and parking requirements, have a couple of common sense purposes. One is safety and practicality. Just like building codes, you ensure that after you build it, you can park and turn around instead of backing out, like we talked about when the traffic engineer was here. The other purpose is to constrain the intensity, the population, the number of occupants. There needs to be more space between a building with 20 occupants and its neighbors than a building with 5. That the law says that and common sense says that. There is not enough space between this building and its neighbors for 12 people with cars. Okay, it's a funny lot. It's an acre, yes, 45,000 square feet or whatever it is, but it's long. The setbacks to the sides are very narrow. I live right next to it, and I've got 5 box air conditioners blaring right at me, and they're 20 yards from my daughter's bedroom. And I hear the box air conditioners going, and I see the people, and I hear the trumpets playing in the middle of the night after our last zoning meeting, which is just bizarre. But anyway. There's just not enough space. These are nice people. They need a place to live. They need to be able to come and go as they please. We don't want to set up a situation where they can't peacefully occupy their property. That's not in anybody's best interest. We want to be friends with our neighbors. They're young people. They need to party. They need to have guests. We don't want to set up a situation where they agree to so many stipulations that they're not going to be able to comfortably enjoy their property. That's not what zoning's about. Zoning's about mutually all the people in the town, all the people in the neighborhood, all the property owners can benefit from their property, right? And the proximity of these properties is why the ordinance specified these setbacks, and it's a way to constrain the population and the intensity. And you should not vary from those setback requirements. Unfortunately, it seems all these students want to have cars, and so in addition to the number of people, we are really concerned about all the cars. I don't know why, all the students have to have cars. All the students on campus don't have cars. I think one of the main reasons, one of the draws for students to come and live in this place is probably that they would get to have parking spaces. So what can we do? Well, As a zoning board, you really only have one lever at this point, and that's not to offer the setbacks for the parking. And I think that's what you should do. If you visit this property, and some of you have, I guess, and you've looked at the diagrams, you'll see that it's set back far from the street, and you'll see why aesthetically and functionally parking in the back actually doesn't make that much sense. I actually agree with the applicant and the applicant's attorney that it would, I don't want to throw my neighbors under the bus here, but since I live in the back, these are my interests I'm representing. And if you look at the situation, you'll see it doesn't really belong. But the neighbors are right, too. The parking doesn't belong in the front either, in the way the law says. Where does the parking belong on this property? Exactly where it was. It belongs in the garage and in spaces, I think it's 7 and 8, right next to the side of the house. It's very obvious. It fits perfectly. Parking really doesn't fit in the back, and it really doesn't fit in the front. And you know what? It's totally natural, because there's room for 3, 4, maybe 5 cars on this property. There is not room for 8 cars, 10 cars, 12 cars we've heard about, 15 cars we've seen in the photographs in the evidence. There just isn't room, and you shouldn't grant the variance to allow that room. Moving on, try not to use too much more of your time. More importantly, what the neighbors are really worried about is once we normalize and approve this use as not a single-family house, but as a house of worship, the next buyer can have a whole new set of rules. We've talked all about these rules and curfews and, no women coming and going and no guests and, oil-changing parties. I think most of it's irrelevant. Not only is it unenforceable, but future owners may have new ideas, okay? Also, we're very concerned that this is a dorm, but it's actually worse than a dorm. It is as bad as a dorm, because it is a dorm, but it's worse than a dorm because it's a home base for St. Paul's Outreach and its missionaries. Now, I'm sure they do great work, and they're important, and I'm glad that I have them in my country, and I'm glad that I have them in my state, but they really don't belong in this neighborhood. I don't think they'd be happy there, and we wouldn't be happy with them there. Seton Hall is a factor in this situation, right? They are packed onto their campus. If you walk around that campus, it is dense. They are busting at the seams because they are constrained by their property lines and by their fences. And there is pressure for them to come out into the community. And that tension is real, and it's not going away. And you're going to find, whichever way they want to come out, Seton Village, they've already managed to leak out, there's going to be resistance. And that's what you're seeing here, right? This variance is an acute threat to the quality of life of the people in this neighborhood. But it's also a long-term threat because of the potential ongoing increase in the intensification of the neighborhood. Right? It's clear to see what could happen. Okay, it's an increase of the intensification of the traffic, of the population, of non-families, of people with different, way they're going to use the land and the different way they're going to participate in the neighborhood, of parking, of pollution, and frankly of asphalt and drainage, all of these issues, okay? The addition should not have been allowed. If we're discussing anything, as one of my neighbors said earlier, it should be how we undo that wrong, right? But that's not really what's before the board today. But one of the things the neighbors are really worried about is putting the stamp of approval on that and getting, normalizing it. And I don't think we should do anything that advances that agenda. So, as I said at the beginning, one of the things that they've tried to convince you and convince the neighbors is that, the alternative is so much worse. And I say call their bluff, okay? They want their tax exemption. It's not in the interest of the town to give them that tax exemption, okay? I know that's not what the board, that's not the issue before the board, but if you're worried about our best interests, don't worry about it. Don't grant them the variance. That's the power you have, and you have every bit of reason to not grant it to them. Things like the tax exemption and the lack of their ability to have meetings will take care of the other problems, okay? If you must grant, for some reason you decide, okay, and I think all of us tonight have presented good reasons why you shouldn't, let's drive a harder bargain, okay? Just 10 people without cars, just 12 people. How about both? And how about less? How about the 3 or 4 or 5 cars that I think reasonably fit onto this property? How about the 8 people that you might expect to find in a single-family home in this neighborhood? So just in closing, I know the board is concerned with doing right by the law and doing right by the applicant and by the neighbors and the town. You're really concerned about the potential for expensive litigation, and that's very responsible of you. But let's look at the record of what we heard tonight. We heard a lot of evidence, and this is clearly a very vexing decision. It hasn't made itself plain over 12 hours of testimony and decision-making. It's not like the court could say, if there is indeed a case, that you've plainly erred. All right, this is a very subtle business. You've heard from our attorney and our planner and from our neighbor, Deborah, who also happens to be an attorney, that a house of worship doesn't really fit on this property, and also that this is probably not a single-family use, and that this property as a house of worship does not meet the setback requirements. And you've also heard, more passionately on less technical grounds that it doesn't fit in the neighborhood, which is actually a real zoning issue. These kind of blurry, gray, less technical issues are, in fact, the stuff of zoning boards and planners. And you've heard that for common sense reasons and the intensity of parking and the population, that it doesn't belong in the neighborhood. And so for all those reasons, I hope you make the right decision and deny the application.
Thank you.
Do we have other comments?
I think we're done. I think everybody's
Want to
ready.
give a summation?
I will be brief and hopefully leave the board enough time to ponder over this. We are a religious building. That's what we propose here. We are not a church that's going to hold services on Sunday. As a matter of fact, the testimony is, and I'll state for the record that we agreed to a condition that we not hold public open services. And we agree to that because that is not what St. Paul's Outreach does. St. Paul's Outreach is a religious Catholic organization whose mission is to promote both their faith and religious lifestyles. Their household program is essential to the religious mission, and their goal is to equip young Catholics to live out the call to holiness in their daily lives. Their proposed use in many ways is quite similar to what the Salesian brothers did. Now, I know that the Salesians were not before this board and never got zoning approval, and I'm not asking you to find under Section 68 that this was a prior non-conforming use. But the fact that the Salesians were there for 25 years, and for many of those years, St. Paul's used the property because the Salesians, with time, became fewer and fewer, and eventually they were so few people that despite the fact that at one point they paid for an addition to make this house into a 14-bedroom, 10-bathroom house with a chapel, at the end there were 2 or 3 people there, and the neighbors got used to that. And I understand their concern. They got used to a 7,000-square-foot house with 3 people living in it. But that is not sustainable, and that is not what this house is ever going to be again. That time has passed. The site plan we've proposed will improve parking. It'll put 2 cars back in the garages, which are totally unusable right now, and will make room so cars don't have to jiggle around, and for one person to leave, somebody else has to move their car, which is what they have to do now. The photographs that to the objector, Mr. Lopez, and the other man submitted really don't give you very much information. One of them shows 11 cars there on a Monday. This is an acre of property. If you had 7 houses on Terrell or 7 houses on Irving Place, that took up an acre of property, you might have 20 cars there. I live in a one-family house with a very steep, narrow driveway. I had 3 sons. We had 5 cars in the driveway. We're trying to make it better, and I think the site plan we've submitted will improve the current situation. The curb will keep rainwater from going on to Irving Place, will build any addition according to code. We're proposing to add 30 trees to screen the property, to beautify the property, and to mitigate any detriments from the cars that will park there. And we also agree, and a condition that you may want to impose, we think the best condition is to limit the number of residents with cars to 11, where we have 11 spaces. The photographs that one of the objectors submitted, one of them had 11 cars on one Monday, but there were like 10 other photographs showing 4 cars, 6 cars, but not really that many cars for an acre of property, because during the day a lot of the residents leave, maybe they have jobs, and then sometimes the missionaries walk from Seton Hall. They are close and interrelated with Seton Hall, but it's a separate 501c nonprofit organization. It's a religious organization. They need and like this property because the chapel is part of their religious mission. And religion is favored under the law, and it's protected under the law. And it's also an inherently beneficial use. We mentioned the Sika test. First, the board should identify the public interest at stake. A religious use is highly protected. It's inherently beneficial. It's a religious and charitable use. It's a religious building. We're not a house of worship in the sense that we're not, and we're agreeing to a condition that we will not have open public services. That's not what St. Paul's Outreach is about. They want to affect students that are inclined towards being religious to live a Catholic religious lifestyle, to include God in their lives, and they could do this only with a residential program where they have strict rules, where they teach young men not only to cook and to clean and to take care of themselves, but to live with other people and to do charitable deeds and good deeds. So the use is a very highly important, inherently beneficial use under New Jersey state law. And there is no getting around that. This is not a fraternity. Now, then the board and the Sika has to identify the detriments. We heard a lot of neighbors complain about parking, complain about cars, and complain about people coming and going. But basically, the objector did not bring an engineer to testify as to parking. We had a traffic engineer who testified a few months ago, and he stated that he went to the site, he analyzed the traffic, and the traffic from this use will not even approach, and the exact words he used was it will not approach significance and will likely not be discernible from the existing conditions. The objector's photos really show that there's plenty of room for cars. With one exception, there were 11 cars, but if the site plan is approved, there will be 11 parking spaces. We didn't want to originally propose striping the driveway because we thought that looks a little less residential, but if the board wanted to impose that as a condition, we'll stripe the driveway if the board thinks that would also mitigate any detriments. we'll agree that there would be no large meetings starting after 10 at night. And we also agreed to 3 restrictions that are permitted right now. We will agree that we'll never use this property as a homeless shelter, that we'll never use it as a house for abused women, that we won't use it as a soup kitchen. So those are things that could protect the neighbors, and those are ways that we could mitigate the detriments under SECA. And then when the board balances the benefits, the religious use, the highly inherently beneficial, protected religious charitable use against the detriments of possibly a few more cars than 7 houses on an acre would have, you really have to weigh this. We've had no competent testimony by an engineer or by a traffic expert as to any problem on South Place due to this property. The objector's attorney knows many traffic engineers. They chose not to submit any such evidence, probably because they looked at it and they knew they couldn't prove these kind of detriments. Everybody would like to live next door to a park or an empty lot with lots of trees and lots of grass and nobody living there, or maybe one person living there. But we have a 7,000 square foot house, and the use proposed is probably the best use that the neighborhood could have. It's walking distance to Seton Hall. It's walking distance to public transportation. The board really can't deny this under New Jersey law because there really aren't significant, substantial detriments from this application. And that's the standard that the law requires you to use. And I know this board has a terrible job tonight, a really tough job. I know it because I've sat where you've sat, although not in this building. And it's a tough job. Why do you volunteer to do something and have your neighbors sit and make faces at you? But the law is really clear on this. You have to weigh the detriments against the benefits, and in this case, the benefits are really clear. And I hope you'll do the right thing. Thank you very much for taking all the time and patience to sit through all the witnesses here. Thank you.
Thank you. Okay, so the decision we make now is more of a procedural. Do we start the debate on this at this point and the dickering back and forth? That if we were at all considering approving in any way, going back to the applicant saying, well, what, limiting conditions? Because I see, if you all are thinking about that at all, they would be talking about limiting conditions and going back.
You're
and
asking
forth.
a question about time.
Yeah, time. Do we want to do this tonight and jam through it here?
Absolutely not.
At 11. This is why I'm asking the board.
I think
if you all want to do this now, or you want to do it when you're
Sharper.
frankly fresher.
Yeah. We should do it when we're all fresher, and I think we should really give it a lot of thought, and everybody should come back here with their thoughts and their comments. Because it's not an easy decision.
Okay. Does anybody else really want to jam through this?
I guess, from my point of view, we have the public who've been here 3 nights for 3 long meetings. And I guess I don't think it's a long discussion, so maybe that's...
Oh,
I totally disagree with you.
I disagree as well.
Entirely.
And the public, in all fairness, won't have the opportunity to speak anymore, so they could sit in the comfort of their homes and watch us deliberate.
On TV. That's true.
And reality is that either decision that's made this evening will require a lot of laying out of details that we want in the documentation that I'm not sure that I'm prepared to go wrangle through to make sure that we've got everything lined up. But I think we'd benefit from having some time We could have a special meeting, perhaps. It's a short.
Okay, we're going to adjourn. We're going to adjourn, but if we're going to adjourn, what I want the board to do is think about this and at least have an individual plan on your own of what you might like to do, and to discuss with the other board members. If you're going to say no to this, lay out the reasons. Better be clear. Better be within the law. Can't be hysterical. And if you're at all considering this, then there would be conditions, obviously, on something like this. You would need to consider what those conditions were and be specific about them. Does that sound reasonable to prepare it? I mean, in your own heads, these sorts of things. We can't get together. That's not legal.
I do have a couple of questions I thought that the board might want to consider, and I'm hoping that we could get more information on it before the board makes a decision. There are some issues that were raised this evening that I think bear consideration. One of them was a point that was made by the objector's attorney, that there was case law to the effect that use creep could occur if a religious use was allowed here, and to what extent the board could limit that, so that if granted, the next user or this user could go beyond what was contemplated by this application. So I would appreciate any input either the objector's attorney or the applicant's attorney wants to provide on that issue. I also would think that we could use input from our zoning officer with respect to two questions. One was the interpretation of that rear yard setback issue that was raised by the objector. And secondly, the interpretation that I think we all need to take a look at, Susan, myself, and Sal, as to actually how many students or how many people could live there as a purely residential use, which I think is relevant to the discussion. So I'm just putting that out there. I think we should try to get that information to the board before the next meeting.
Does that mean a public, again, a meeting where the public would want to come to? I mean, would they, because we're getting additional information, have another opportunity to ask questions?
This is just for the board's consideration. I think that's something the professionals can provide to the board and will attempt to provide to the board.
Okay.
I think whether it's long or short, and for me, this would have been a very easy one, 2 minutes done. Because I would like for some of the members to probably find somewhere in South Orange the situation faced by these folks, like myself, who live close to a house where there are more than one or 2 or 3 students living. And this may probably even tell you where I am, and you would understand what these folks are. They're not saying they don't want the home there, but there are some restrictions that you have to use, and sometimes it's not calling the police all the time. So I think that education is probably important for this board to understand why you have these folks willing to stay here this late at night, because probably if I wasn't on this board and lived in the neighborhood, I would be there in disgust also, because it is not a beautiful thing.
It's not what?
Beautiful thing to experience these students.
Fair enough. So I wonder, since we're going to be waiting for additional information, if it's appropriate to ask Mr. Dwyer to provide maybe a bullet list of issues that have been raised for us to consider.
Okay.
That would be very helpful.
All right, I'll try to get that to you.
You could do that in concert with Ms. Gould, possibly.
Okay. And to the extent that either Elaine Birkenwald or Rick Skolnick are going to submit something, I would request it be at least 10 days prior to the next meeting.
My client cannot make the July or August meetings, and so if we can't do it tonight, it would probably have to wait till September.
Well, we need your client to be there, because we're going to be talking with them possibly, if it gets to that point of conditions and stipulating the conditions, these sorts of things, they've got to be there. The client has to be at a meeting.
He can't make it in July because there's a national conference of St. Paul's.
So when could they?
September.
Don't you agree that they need?
Unless you could do it the next week or so, or two.
What? So
The other possibility is perhaps the board wants to vote on the use and leave the resolution and conditions for September. And we will consent to extending the time.
We're not going to take any vote this evening.
Okay.
We're not. It's.
When
do you all want to have a special meeting, assuming we could get one? Or do you want to wait till August?
My client can make
July or
August. We've discussed that. We were really hoping it could go tonight.
You should really try to get a special meeting in.
At what point does your client become unavailable?
Have a special meeting in June. Let's knock this off.
Have a special meeting in June.
You would want a Tuesday in June?
First 2 days I can't, which I can't do. Any other day I could.
I don't know if I'm allowed to speak. I obviously want to be there. I respect that. I think I need to be there. This is obviously I think the fourth hearing with the review for completeness. It's been a lot more than we've expected, and I have travel. I'm just literally out of state in July and August.
So what about June?
The 23rd.
How about the 23rd of June?
That would cost us $1,500, right?
I can't make that date. I'll be.
And I just don't know if we can afford $1,500 with all of the.
The fee.
Yeah. So we'll just go to September, right? I'm sorry, somebody's speaking just from the audience.
Wait, I'm not taking any testimony from the public at this point. You all have to be here. You don't have to be here. They don't have to be here.
Doesn't have to be here.
Can we decide, to?
Listen, we could have a meeting.
We could have a meeting without them.
If we decided that we were leaning in favor but with conditions, we could send a letter to the applicant and say, here's, we could do it that way, right? There are a number of things we could do.
Right, not vote
It
until they
wouldn't
respond to
be-
the letter.
It might not be the most efficient way to do it, but we can have a meeting without the applicant. Because at this point, we've finished taking testimony.
Yeah, they don't have to say anything.
Yeah.
We could have this meeting tomorrow.
Here's what I think is something that the board ought to think about is if the board were to decide to grant the application with conditions, it would be helpful if the applicant were to stipulate to those conditions as part of the record and agree to those conditions, because I think that would help in the event there is
An issue
later on. So that's why I would prefer the applicant to be here, and I'm hoping we could do it in June.
They don't want to have to pay the fee. Is there a way that we can waive the fee?
We don't get paid?
We don't get paid. You can charge it against all of my credits from working these meetings.
I guess the question is to the applicant and Mr. Mosia? How late? When is it in June or July that you're no longer available, and then we can find out if the hall is available.
I can make it the 10th or the 15th of June. I really don't have any other dates available.
I can make anything in June work. I'll make anything in June work.
I am away from the 17th.
Well, we're not going to be able to pick the night here because we don't know when the
Yeah.
when the hall's available, so it's going to require notice in any event
I
of
think
a
we
special
just-
meeting.
The waiving of the fee doesn't sound like it's a good
If it can't be tonight, it really has to be September. Is it September 1st or the 8th? September 8th, probably, the next meeting, right?
Jetta, when is it in September?
September 1st. 1st, okay. That's before Labor Day.
Could we do in June with a special meeting without the fee?
I'm not sure about the fee. I think it's probably going to have to pay the fee. So.
I can't, I'm not in a position to be able to say you can waive that fee. That's not my authority to do that.
You can make the application. I don't know if it's going to be permitted or not.
Do a collection at church.
And we'd have to, and we have to make sure we could get that this room or the room upstairs would be available.
Right.
So basically, any time in June, you're available?
That's correct.
Any time in June,
I'll be abroad from June 17th.
you're not available
I'm
on...
not available after June 17th.
Not available after June 17th.
Right.
Forever?
Till September 1st.
Where do I get that game?
So it'd have to be before, does that give time to give notice to people and?
Get the information that we need.
That's
and
not enough,
such.
that's not enough time.
We've asked for
Well,
substantial.
most people we get notice to.
Well, it's just a special meeting. You have to notice. a special
You have to
meeting.
notice. So we're stuck with September.
We've got plenty of time to think now.
Yeah, right. Unfortunately, due to the applicant's attorney's schedule, I don't see how we can do it.
Yeah.
I apologize, not wanting to make a decision tonight. It's just there's so much documentation that has to be done. I want it to be a solid decision, and I want it to be defendable, because either way it's going to need to be.
And as I said, this was an easy one for me.
Okay, it's not so easy for everybody
I know,
else,
I know,
perhaps.
I know.
Well, look, if the app, do we want to hold it? I don't think it's a good idea to hold it without the applicant here, but, waiting is not good either. I'm not inclined to do this without the applicant.
My client said he could make it after July 12th. Monday is the 13th, July 15th.
Why don't you guys?
But I don't,
Yeah,
how do you
let's not do
find
this. Let's
out?
not do this here.
Yeah, let's just go away and
Can you just let us know
let us know
tomorrow
when you could do it.
what dates you're available?
We will tentatively schedule for September because that's a fallback.
Yeah.
We can always meet in September. That's a regular meeting. If you all can come up with additional days that would work, and we could find a hall here, and it would work, and you're willing to pay,
And it's enough time to notice.
and it's enough time to notice, then we'll do that. Okay, so contingently for now, the next meeting for this is September 1st, Tuesday at 7 p.m. The neighbors will receive notice if it's before then. Is that reasonable? Sound reasonable?
Mr. Skolnick is not able to accept notice on behalf of...
Can't hear you. Wait, you got Mr. Skolnick. You need to use a microphone if you're going to speak. You've been addressed. You might as well come on.
Can't control the date, but a certified letter getting mailed 10 days before a hearing in the middle of the summer is not acceptable for anybody. Could be on vacation. Letters could...
That's true for every land use application, all summer.
Take it and make the applicant come back, like every other applicant. Rearrange your schedule. Come back in the next hearing date. That's what people do. They rearrange their schedules.
Okay, all right.
It's very unfair for the neighbors to have to wait 3 months. That's an incredible amount of uncertainty on a critical issue.
It's not uncertainty at all. It's not uncertainty at all. It's September. That's what we've got, is September for right now.
No, that's not what he's talking about.
Okay, so we're gonna do September unless we hear otherwise. Okay.
Thank you.
Good evening.